talking about. This is the, I'll approach if you'll let me.
Explain to me how the two connect.
Yeah, this is a report.
All right, guys.
Of the.
I'm stopping it right here, but I think I have to explain this. All right, so we're coming in hot because the trial has already started. But so the defense has just gotten a book, like literally a book like this size of burglary and reports that they believe were committed by Ahmaud, Arbery, or that have some relevance to the case, and they got it from the state. So the state is asking that this evidence of all these burglaries and calls and suspicious person calls not be entered into the trial. So that's what they're arguing now. I'm going to just put it on here. Good morning, everybody, but I'm going to put it on here so we can hear this, because if this comes in, this is going to really be damaging to the state's case in the Ahmaud Arbery trial. And then we'll go over a little bit after that. So let's continue to play so we can hear this.
Stack of papers that we just went and actually got the reports of. So Ms. Dunikoski gave us this list. Incident number 1, neighborhood patrol on 1/1/19. Number 2, shots fired 1/1/19. Number 3, neighborhood patrol 1/7/19. Number 4, citizens assist 1/26/19. And the list goes on and on and on. This was generated for the state, who gave us a certified copy of it in reciprocal discovery. Now, what we did, Judge, is we went to. Okay.
It's dated.
Okay. Well, this is the certified copy that I guess they gave us in trial. But this list of cases is a list of cases that's been about the neighborhood. They just pull all the 911 calls in the neighborhood. So we pulled the CAD reports for that. We had a lady come in and testify.
Police reports associated with
CAD reports, Judge. CAD reports. Those are the computer automated dispatch report that comes out. And there's maybe other reports with some of them because they're more detailed.
Trying to get on the same page. You're showing me the document that you have, which is the CAD reports. What I thought.
I showed you a list. That's all this is a list.
Okay.
I showed you.
Let me just make sure I understand what's out there. Because what you were saying was they were the CAD reports, and these are police reports associated with the CAD reports. But this is a different list.
Yeah, I'm just starting from the beginning. We were given a list of incidents where the police were called in Satilla Shores. Okay, this is just a list. It's a 6-page list of all the 911 calls, just noted by incident number, the nature of the call, the area, the reported time and date, and the disposition. And it just lists them one by one, and it goes from January 1st, 19. This list goes actually all the way through May 25th.
The document you have in your hand was provided in discovery. Explain to me what that is again. That's the
Yeah, this was provided and I believe exchanged in discovery, which is just a list of all the 911 calls. Okay. I guess on November 10th, the affidavit of custodians of records was signed by Cherry Batchelor, who testified in court.
I'll give everybody a quick catch up on the trial.
And I think Ms. Batchelor was used to get
after they when they break
specific calls.
But this is important. There are many calls in this neighborhood.
Knowing about these cases,
the
state has known about these cases.
There are many calls in this neighborhood for somebody prowling the neighborhood.
We intend to demonstrate that there was a lot of concerned neighbors in the neighborhood of Satilla Shores. There was a lot going on. There were a lot of extra patrols. There were a lot of extra watches requested, and there were a lot of suspicious persons. And our goal is simply to note the location, the house that was called, that made the phone call, the date, and the nature of the call, either suspicious person or neighborhood
Jesse
patrol
Jackson's
or
in the courtroom
watch.
too.
These are things, to a certain extent, Officer Rash has testified about. He said, I've patrolled that whole neighborhood. I've gone up and down the streets. I've done extra watch. We've talked about the nature of a suspicious person's call. We've had evidence about that. We've had what neighborhood patrol is, what extra watch is. And so all we're doing, and Ms. Dunikoski, maybe we should have talked before, but what we are seeking to do is simply establish that there is a high volume of suspicious person calls in this neighborhood, and that there is a lot of extra patrolling going on in this neighborhood, and that a lot of that then bled into the Facebook page, which we'll deal with through our witnesses. But what we're seeking to do is tender these documents into evidence, not have them go out with the jury, not call a witness to come in and testify about all the details of what happened with that, but just to establish that there are suspicious persons calls being made by the neighbors in the neighborhood, that there are extra patrols happening, and that there are extra watches happening in this neighborhood. And what we would intend to do is simply use the date or the nature of the call and the address it's associated with. And so those documents, we want to put them in. They're authenticated and they survive. We have the business record exception of the document. We have that certification by the custodian. They are now self-authenticating and they are business records, so they would be admissible on that certification alone. And then what we would do is just simply tender to the jury.
Oh, thank you so much. Yeah, this is
a call for suspicious person.
Rittenhouse is crazy, but
and if the state wants to go through them and disagree with that this suspicious person was resolved as irrelevant, then we certainly can do that. But we would simply want to establish that there are calls about suspicious persons in and around property, that there are requests for extra watch, there are requests and there are extra patrols.
The defense is trying to build up the neighborhood was being terrorized by Arbery. So they want to bring out all these 911 calls to show, hey, look at all these 911 calls. Look at the neighbors are screaming, help us, help us, help us. This is guy
and he is also
prowling around and scaring us up. So that's what they want to show in. And the state says, no, don't bring this in. So that's where we're at now.
Every time 911 is called, but it is a fact that is relevant to this case, that this is a neighborhood that's experiencing a lot of crime and the police are focused on it. It would be consistent and it would corroborate a lot of the testimony that we've had. And so to the extent that it does corroborate that testimony.
Not guilty, all counts.
And it establishes just very basic
Yeah, Rittenhouse is not guilty. When that verdict comes in,
I think it's relevant.
So everybody understands we might be switching back and forth. So if Rittenhouse, when it goes out to the jury, we're going to, stay with this. But then when they come back, I'm expecting them to come back today. So I'm expecting Rittenhouse's jury to come back today. You could, they're going to go out today, this morning at 9 o'clock. They're going to get the trial, but I'm expecting they come back today, and I'm expecting it's going to be not guilty. They may do another 2 days. If they do 2 days, I'd be shocked.
In the nature of the call and the time period of these calls.
I can see them first vote not guilty on all.
We're not. We're going to say suspicious person call made on this date by this residence.
Do you guys think this should get in?
We've already had testimony
all these
about what a suspicious
calls.
Person call is.
I'm doing a bad job. Number one, so the state's argument is, all right, so just so everybody understands, there's a book of 911 calls about suspicious person, burglary, all that stuff, right? There's a book, like a page book. And they're saying, we want to put the jury in the minds of the people who are living in this neighborhood. That, hey, we had some crazy guy going around and people were frightened and scared. So we want to get this in here. So we want to show the jury the state of mind of the McMichaels and everybody else in this neighborhood. The prosecutor's saying, well, this is irrelevant because unless you could show us that it was Ahmaud Arbery who was doing those things, the only thing it's going to do is just poison the jury, make them think that that's him when it may not be him. So that's what the arguments that you're hearing now. I hope this makes sense in this moment, but I know we're a little late, but that's the crux of the argument. So that's the defense attorney now is trying to argue.
Testimony on extra patrol. We've had testimony on neighborhood patrol by Officer Rash. We simply want to corroborate that with these documents.
That's the issue now. Well, I'll talk about
get into all the details.
The legal arguments on both sides. I still believe they're guilty, but they got an argument. Let's not kid ourselves. There's a lot of people who go out there and say they don't have an argument. They got a pretty good argument.
In January,
they could be found not guilty. Don't sleep on this
citizens
case.
Assist, if that's included, that may just be. But
with the evidence that we've seen so far, which I'll go over in a couple of minutes.
For example, citizens assist.
Yeah, that's not one that's really relevant. That could be somebody who fell down.
So, for example, I'm trying to figure out how you're not going to start getting into what these documents are. So you plan on asking Dial about this?
Well, Dial, we certainly could ask about his investigation and his understanding of what was happening in Satilla Shores and how he may have investigated that.
So how do you plan to use this?
When we present our case, we intend to say, Your Honor, at this time, we seek to admit defense exhibit number, put it in the record. Then, at that time, if it's admitted, then I will say on January.
They have to be careful
1st,
on how they let this in, because you don't want to make it seem like it was Arbery
there
doing
was
all
a
this.
neighborhood patrol that
But
was conducted. On January 1st,
I even got the neighborhood patrol
2019, there was another neighborhood patrol conducted. On January 30th, 19, there was a theft injuring auto reported.
Yeah, I'm keeping it real. I see not guilty. That
March
prosecution's
20th,
closing
19,
yesterday was
another
horrid.
neighborhood patrol. On
Horrid.
March 23rd, 19, there was a suspicious person reported.
That
On
prosecution's
March
closing was
26,
ridiculous.
19, there was a neighborhood patrol. And go so on. And that's it. I want to establish that the citizens are calling and requesting police intervention.
Thanks
It's not a
again.
new subject to the case.
Thanks for becoming thanks for joining.
We want to corroborate what we've asked on cross-examination. So there's no unfair surprise, and we're not going to get into all of the details of it. Certainly the state, we can, if they want to go one by one.
Now, don't forget, this evidence, this is state's evidence. States turned this over to the defense, and now the state's saying, well, we're surprised by this evidence.
Are you going to link this up to anything the defendants knew, or are you just going to say this is what was out there as far as this record?
This is, what we're doing in our case in chief, just essentially and generally to try to respond to the court's question. We are calling residents of this neighborhood, residents who have experienced their own crime, residents who have participated in the discussions on the Facebook page to which Travis McMichael and his father and family had access and looked at. We will be linking that up through testimony that's relevant to Travis McMichael. And this corroborates essentially those witnesses and other people in the neighborhood who have experienced problems. These are public records, Judge.
Yeah, I understand.
Yeah, okay.
Yeah, they don't go hearsay. They're going to be in. I think you're going to let them in.
I think the other defendants.
Yes, Your Honor. Teresa, can you hear me here? I'll pop up there.
So obviously the defense wants this in, right? The defense wants this in. I would want this in on the defense.
Point out that when we began the trial, of course, we had the initial list that the state had provided. It became clear after the opening statement and several witnesses, beginning with Officer Duggan, that there was an attempt by the state to characterize through minimization what was going on in Satilla Shores from about October 2019 to February 2020. There was a question, can you describe the level of crime? They get their fair share, and the court is not going to recall this, I'm sure, but
I remember testimony about Baker 9,
and
what the officer's impression of the level of calls and all of that were.
Yes.
So that's why I'm wondering why this wasn't discussed with that officer, why that testimony wouldn't have been challenged.
Because there had been an attempt by the state, I believe it was Ms. Olivier doing that, Officer Duggan. So not much, she said, not much. And I objected, no, that's a characterization. And he stood for himself and said, yeah, their fair share.
It was more than Duggan, I thought.
But Duggan's not the Baker 9 man.
Please don't cut me off on.
Oh, I didn't mean to do that. I'm sorry, I didn't hear you.
I'm just because I'm trying to work through this. I remember at least one, maybe more officers that were asked about activity in Baker 9.
Poll question.
And what their call volumes were.
What would you do if you were the judge?
Calls that they were responding to.
Yes, and I agree with you in a general way, but the state has in one portion of their case attempting to minimize and has said that there were 3 entering in autos, one of them was Travis's, and 1 burglary, which turned out to be not a burglary. Our position is, if you're living in a neighborhood where patrol cars are coming out to respond to these calls, whether or not it turns out to be something that was confirmed, whether or not a suspicious person was located, this raises, as we'll be able to show in the Facebook page, people's level of concern. So the question
They had a
of
neighborhood
the
watch
timing
Facebook
of
page
all
in this
this and
community.
how we
Shows you
intend
how
to
much they're
introduce
concerned.
it and why
Wow.
now deals with it is a direct response to the state's desire to minimize what has been going on in the neighborhood, which the neighbors will, I think, directly refute.
Mr. Scott.
I'll explain what again, it all depends on what the defense's argument is. The defense's argument is that these people were trying to arrest Arbery for burglary, and their state of mind was that there was a burglary committed. So that's why they're arguing this point out. The relevancy is, was their belief that Arbery committed a burglary reasonable? And that's what they're trying to show through this evidence. This isn't the only evidence, but this is what they're trying to show.
Really, there's one specific issue I want to address. I think I've noticed in the court that we sometimes feel like the red-headed stepchild sitting over there in the corner. And I've noted before that we tend not to get served with things from the co-defendants in this case. And for the record, I'm holding the document that.
See, look how many reports there are. See that? See what he's holding up? That's it.
I think this is the first time that I've seen it. Actually, I haven't read it yet.
That's a lot.
I guess there's a little bit of trust there, but I'm going to adopt it. And as far as discovery purposes,
the state of mind, they're very critical, extremely critical.
This is the first I have possession or knowledge of the document. This is the earliest opportunity that I could use.
Those are all reports. Look how thick that thing is. That's like a book.
There, I would join the McMichael defendants in wishing to present this document in defendant Bryant's case in chief. Thank you, Your Honor.
Final word from state.
Thank you, Judge. I think Mr. Sheffield actually made my point for me. The document I served on them is the Spillman list. I attempted to get Parker Marcy to talk about it, if you recall. I asked him specifically, did I ask you to verify the Spillman list? I asked you to look at this list and pull up these various things, this burglary call and these entering auto calls, the few that were on the list of 126 out over 14 months. And he was prepared to testify to that and to talk about them. They objected. They stopped the state from doing this and going into this. And at that,
I'd like to be heard on that afterwards.
and then after he goes, I'd like another chance to come back because I never seem to be able to get the last word. But I would.
From the state.
Thank you, Judge.
It's getting chippy now.
The list that I had Ms. Batchelor, Lieutenant Batchelor certify was served in discovery. And it was served in discovery back in, I think, the end of 2020. So everybody had that list and knew about that list. The anticipation would be that, of course, someone would testify to the number. I want to point out to the court a couple of really important things. In opening statement, Mr. Rubin got up here and said, Satilla Shores was a neighborhood on edge due to the crime.
Okay.
So what's the state supposed to do? We're supposed to not address that issue? They brought it up in opening statement. It's been a theme. It's been a drumbeat with the defense.
You see, that's what the defense's
Constantly.
argument is.
This neighborhood's on edge. All
Neighborhood's
these people
terror.
are having, backyard conversations now.
Now you bring a
via
book.
Facebook.
Police
And
calls.
everybody
They got a
knows.
Facebook thing, yeah.
Mr. Sheffield just told you the purpose for this. He just told you, we're going to argue the neighborhood was under attack. He just told you that's exactly what they want this evidence in for,
That's
to show
right.
that this neighborhood was under attack.
If I was the defense, I'd
Problem
want it for
is-
that reason too.
is unless I'm allowed to address that we got roommates that are having problems, the neighborhood's not under attack. We got somebody who thinks a car's not supposed to be there, and oh, lo and behold, it is supposed to be there. One of the guys on the green tab called up because his subcontractor showed up on the wrong day, and he was calling the police because the subcontractor wasn't supposed to be there. So this idea that the neighborhood is on edge, I mean, at that point, Your Honor, absolutely. If this is allowed in, I'm going to go through every single one of these with Dial so he can explain to the jury that this call came in and it was miscommunication. This call came in about some roommates.
So she's saying,
And
so what
the
her
idea that
response
Travis McMichael knew about some
is
roommate
that I'm going to
disagreement
it's going to
inside
take
a house?
a month for us
The
to go
idea
through
that
each one
somebody
of
called up
these.
and said, I can't find my credit card, and Travis McMichael knew all about that. I mean, it's ridiculous.
See, somebody lost a credit card.
The list that I provided to them that Mr. Sheffield just said he would go through that list. He said he wanted to go ahead and do the date and the nature of the call.
She's
What I
arguing
served
that
on
most
them,
of the stuff is
which
irrelevant,
Parker Marcy was
which I think is a good
talk about,
response.
was the nature and the date of the call. Now he wants to add in the location of that call, which is why now he wants to tender all of these in. So, Judge, I guess it's a double-edged sword. If we're going to go down this route, then I'm going to go down it fully. I do have a problem with the fact that I don't recall anybody talking about what extra patrols were or extra watches were requested. I don't recall anyone testifying to what those things were. I don't think Officer Rash did, or how those things are initiated. And of course, none of this was discussed with any of the actual officers, such as Parker Marcy and Officer Rash, as to these calls. In fact, I think I asked Officer Rash about Rob Ray and the roommate thing, and he didn't know anything about it. So at this point, their argument is this high volume of calls. I guess the other argument they want to make is the neighborhood's under attack. Look at this high volume of calls we have. Therefore, that leads us to believe the neighborhood's under attack. Look at the extra patrols that were being initiated by officers. Therefore, this must be an entire neighborhood that's under attack.
Fair and under attack.
And none of it actually is relevant, because unless Travis McMichael knew that that Officer Powers on November 11th at 9 o'clock in the morning initiated an extra patrol, what relevancy does it have to his state of mind? Because he doesn't know about any of these things. I mean, maybe he's going to go, yeah, I was totally tuned in. I knew every time an officer made while I was at work at Metz and Marine, I certainly knew these officers were doing these extra patrols. If he's going to testify to that, that's fine. But there's no connection between any of these things.
If defendants don't know about it, then how is it relevant?
Your Honor, we ask that this either, I guess, be completely excluded, or I guess that you allow the state to thoroughly ask Agent Dial about each and every single one of these, and we'll go through them one by one so the jury understands the nature of my subcontractor turned up on a wrong day. Hey, there's a car that's here. Oh, it turns out it's a miscommunication. Hey, there's some suspicious people walking down the street.
This is good, Lauren, because she wants to say
actually does live at that house.
She's actually making an objection on relevance, right? She's making an objection on relevance.
Put it all in, or we don't put anything in. Because just to go, here's the number of calls, so therefore this neighborhood was under attack, and here's the big sheaf of papers, that's unfair to the state. And so if we're going to do this game, the state's going to walk the jury through every single one of these calls. And by the way, in here, there are police reports attached to these. So they're not just 911 CADs. There's actual police reports attached inside here with narratives and investigations. There's also,
mind you, this is the state. So this evidence, right? That they're trying. This is the state's evidence. This is not even the defense's evidence. They got this from the state.
I immediately turned and found one that said citizen assist within here. Here's a copy of a police report right there attached to it. So,
look at all those calls. Look at all those police reports.
And
they don't
want those about accessing a hard drive by an officer. That's the kind of stuff that's included in this. We ask that it be excluded. Either we go down the road totally, or we don't go down the road at all. Thank you.
Or we just go down the relevant.
I don't want additional argument. You want to clarify the record?
Yes, please, Your Honor. Thank you. We haven't even offered this yet. We've just given her the stack of papers. She hasn't even tried to talk to us about this yet. We're not offering it into evidence right now.
Let's do this then. I want the three things that were just referenced. I want to see what that stack of documents is.
Okay.
I want to see what was produced. There was a CAD report list that I understand was produced.
Computer CAD is computer
aided dispatch
for those who don't know.
I want to see what those three are.
Got it.
And I want to know when they were produced.
Okay.
50-50 now. Maybe 60-40. 60-40 in conviction.
Was produced to us in reciprocal discovery. So we'll give you a copy of that list.
Okay.
We intend to pull from, we printed off everything from that and just gave it to the state. We haven't even marked them or offered them into evidence yet. The state is a little premature on this because we have to pull the ones that we're going to use.
The ones that are relevant.
I want to see what's produced because, as I understand it, we're either a day or two away from the end of the state's case in chief. Yeah. I want to know what was produced in discovery and what was just produced, and there were three documents that were referenced. I want to see them. I want to understand what they are so that I have a way to cross-reference what we're talking about.
Perfect. And then to comply with just responding, Ms. Donikoski says it's a discovery violation. was provided to us by her.
Well, hold on a second. I just said I don't want argument.
Yeah.
You said that there was something she said in the record that you needed
Yes.
to clarify.
This officer, the officer up here, was asked to look at the Spillman report and draw a conclusion about whether Ahmaud Arbery was responsible or identified with the thefts or burglaries. That's what we objected to. If you recall, we said this.
Yeah, and I'll go back through notes and try to work through. But the dispute came up when he was specifically asked about burglaries in the neighborhood.
Yeah.
And that was objected to because there were no certified records and we couldn't get in, and the court wouldn't allow the way the state was going about it to get that in. I'll go back and look at it.
Okay.
I appreciate you pointing it out.
Yeah, I disagree with that. But it was more about his conclusion and opinion of whether or not Ahmaud Arbery was involved. And we said, this officer was not involved in those investigations, so he'll just be reading reports from other people, which is all hearsay, and making a determination if
Right.
Arbery was involved.
And we stopped there and I said, certified, as long as we get certified. So now it's certified and you want to present to the jury
Well, that's
yourself the certified report.
Correct? What we want to present is we don't want to, it's not going to go out. What we want to do is we want to establish essentially that list plus the address.
Like
Of
said,
the only relevant ones, Your Honor, sorry. Just of the relevant ones.
You
The
see,
suspicious
so he's
person, extra
attacking
watch,
her
and neighborhood
counter argument
patrol.
about relevancy. She's
Not
like, all these things are irrelevant.
so-and-so,
It's like, no, we just gave you the full list, but we're going to pull out the ones that are obviously relevant to our time frame and what we want to do.
to the state today, then it's actually a more narrow list.
It will become
Yeah,
more
it'll be a
narrow,
more
when we
narrow
present
list.
it in our case in chief.
So this is actually good. So so he's attacking her argument of relevancy.
30 whatever documents.
I'm not sure what the third one is, Judge.
Well, there was
The list plus the stack
plus some.
of the certification.
Yeah.
This is back and forth. So the state is saying they got credit card thefts. It's irrelevant. But
Let me just finish.
on the other one, he's like, well,
And I also
obviously,
assume
we're going to give you a
that
shorter
based
list.
on this, there's going to be some discussion so that maybe this can be narrowed down even further, because we are, as I understood it, a day or two away at this point from where the state had intended to
Close.
end its case in chief. And so if there's additional time and additional witnesses, I guess everybody needs to figure that out. And that's part of what the court needs to factor into all of this with these documents. I don't need a response to that. I just need the documents. We're belaboring the point at this point. And I indicated that state had the last word. Where I'd simply ask, you jumped up because you wanted to clarify the record.
Yeah.
I don't need additional argument.
Great.
Okay. Thank you.
So, Your Honor, I'm going to give you the state's official certified copy that I received from Lieutenant Batchelor on November
So remember,
10th.
the state actually turned this over to the
I've
defense.
received-
And the defense is like, oh, great, we're going to use this. And the state's like, no, you can't use it. So
that
this is
we
like,
know. The best I can do is right now.
back and forth
pull
right now.
this up. And the thing is, Judge, this was served on us by the defense. This certified copy that I made was just a certified copy of what they had served on me via the McMichaels Discovery Store and Go. It was due October 30th. It's dated October 29th. It says all calls.
This is all
list
pretrial
from
stuff outside the
1/1/2019.
outside
So
the
they
presence of
actually
the
got
jury.
it
So
from Cherie Batchelor back then, served it on us. I was using it as
if
their
Rittenhouse
exhibit
goes
for Marcy. I sent it to him going,
to
"Look,
send the
defense
jury
gave
out,
us
we'll
this.
we'll
Please
flip to that
verify,
just to
please
watch
pull it
them
up on
take the
Stillman."
jury out, and then
I
we'll
can
come
take
back
a
here.
photo shot of this if you want to see it, so that you know what I'm talking about as far as the discovery goes.
As much information as I can get on what the documents are that we're talking about would be helpful.
I will take a screenshot of it and email it to an appropriate person that I will be given later, right?
Yes.
I will do that right now.
All right, we getting a jury in there or what, Judge?
Why don't you use the same email you generally use from my office?
Yes, sir.
They're just trying to be fair.
While she's doing that, without taking up any more additional time, Your Honor, may I also say that the actual reports could have just been used,
All right, I'm going to stop this.
summarization of those reports. So
I'm going to stop this and just give you guys a quick little breakdown of what's been going on with the Arbery case, because, I understand that we've all been probably focused in on the Kyle Rittenhouse case, which I have been. I was on Ricketta stream the other day. So I just want to give you just a quick little summary of where we're at in this case and what both sides are arguing before we get to the witnesses, because I know a lot of people just may not have been up on this case. So let me just give you a quick breakdown on what's been going on. I didn't create a good PowerPoint here, but I created something so you guys can at least see what the hell's going on. Let me switch to that, screen share that. Hold on, give me 1 second, guys. I'm screen share to this PowerPoint. All right, here we go. And I am going to present this, view present. All right, let me make sure we can see that. All right, so what the prosecution is essentially trying to do in this case is say that Mr. Arbery's going into this home was just like everybody else. Now you see the pictures on the top; those are kids going into the house. The second one is another white couple going to the house. That white couple actually went in the same day Arbery went in and was killed. And then you have on the bottom Ahmaud Arbery, right? So the prosecution's case is dependent on that. Hey, Arbery was just like everybody else. Arbery, and again, just so everybody, Arbery's not on trial. So they're saying Arbery is just like everybody else. He was going into this house just like everyone else. And, and the reason why he was chased and targeted by the McMichaels was that he was a black man, and him being black, is the reason why they chased him down and essentially killed him because of they essentially, racially profiled him. So that's the prosecution's argument in a nutshell, and that Arbery didn't commit any type of burglary, and they've been making arguments to say he didn't commit a burglary. Even if they would have arrested him, it wouldn't have been for burglary, so forth. So they've made all those arguments. And then they used the homeowner to also solidify those arguments. Arbery's an innocent guy. He didn't do anything, yada, yada, yada. So that's the prosecution's argument. And I think it's a good one, right? It's a good one. All these people going in, none of these other people were killed. Why chase the black guy? Why run down the black guy? What made him so unique than all these other people, right? And we have pictures and video of many people going to this house, right? And also, last but not least, nobody got Arbery stealing anything. So that's the prosecution's argument in a nutshell. Arbery is just like the rest of these other people, right? Good. And I know I'm doing this, if did these kids commit a burglary? These white people didn't commit a burglary. None of them actually committed a burglary. So that's the prosecution's argument. Now, that's the killer with this case, because if you can prove that Arbery committed a burglary, or they thought Arbery committed a burglary, then you kind of get into this whole citizen's arrest angle, which the prosecution doesn't want them to get into. So that's why this burglary question is very important. All right, going on to the next slide. The defense is going to say, well, no, this is what made Ahmaud Arbery special. October 25th, he's on the camera in the middle of the night into this house, right? These cameras, these are pitch black, these are at night, so you see him at night in this house, right? November 18th, middle of the night. December 17th, middle of the night. February 11th, middle of the night. And then he comes in the daytime. So they're making the print that, hey, this is what made Arbery and the description of Arbery different. Because look at how many times we've caught him there, at these other ones, the children, even though the children are there all the time. But, this is strange. Somebody being in the middle of the night going into this house, and the homeowner was scared, right? And then the neighbors were scared, because then you had the neighborhood watch situation happening. So the two competing theories are, one is that he was just like everybody else going into this construction site, and he was targeted because of race. And the other side is, no, he wasn't just like everybody else. This is him going into there at odd hours of the night, looking around through stuff that makes people scared. So which side are you going to be more likely to believe? Now, how does this all tie into whether this is a citizen's arrest? Well, if they can say that Arbery was a burglary suspect, then you kind of start getting into that. Well, we were trying to arrest him for a burglary that he was committing. And the other side is saying, well, we weren't correcting, for a burglary. We're trying to figure out what happened there. So I know I'm hitting you guys with a lot of information, but I'm trying to just make it so succinctly so we can get back to the case and you guys are all caught up. Now, one of the bombshells that happened, a couple of bombshells, one of the other bombshells that happened, which I'm going to show you now, is that, come to find out, even with this, Mr. Arbery, let me click on this. I'm going to stop this. I'm going to play this real quick before we get into it. Arbery. Now, something that I think all of you are going to need to know. Arbery, they believed Arbery was there about 10 days before the killing. They believed Arbery was in the house. So both police and the neighbors all armed themselves and went into the house to look for Arbery armed, because the police had made the mention that they believed Ahmaud Arbery was armed. So they were going to be careful with looking into, with searching for him. So what I'm going to show you now is that video of the search that was brought up when the police officers. So they were searching with the police. So the McMichaels and all the neighbors were searching with the police for Arbery armed, maybe 2 weeks before the killing, because they believed Arbery was dangerous. They believed he was committing crimes, and they believed he was armed. Again, this is the testimony of the police. So let me just bring that up so you guys can see it. Now, again, I know these facts are going to annoy some people, but I wouldn't be doing my job if I didn't at least give you the facts of what's actually happening. So let me do this. Is it this one? Yes, I believe it's this one. Let me see. Nope, the wrong one. Let me take this down. This is Rittenhouse that I'm still watching. Which one is this one? This one is Watch Live. All right. Sorry, StreamYards is acting up. Chrome tab. It should be Watch Live. There it is. Okay. So this is from the police body cam, right? So the police were actively searching for Arbery about 12 days earlier, believing that he was on that. They didn't know it was Ahmaud Arbery. Now, let's be fair. They knew it was a black guy who fit this certain description. They didn't know the person's name. They were searching for this person actively. So I'm going to show you the police body cam that was found that you see.
Hello, sir.
And you'll see the McMichaels on camera. And everybody's armed.
That's what he's telling you.
Yes, sir.
First time now you've actually confirmed that the guy on February 11th is the guy on November 18th, the guy on October 25th.
Yes, sir.
Still can't catch him.
Nope. Mr. McMichael, saw him and turned in your yard, put the headlights on him, and he run in the house. He saw him run.
I'm trying to see
stuff missing. Yes.
From the boat.
From the boat. Yes.
trying to see if I can get the one where they have the guns out. Remember, this is the police.
We're talking about Satilla Drive.
He is pointing from.
I'm trying to find the part where they have the police in the house with guns drawn.
Yeah.
Road and another car will come up. I guarantee you they're making deals down there. But they're
so again, these are the neighbors, the Michaels. Everybody has guns. They're searching for Arbery because they gotten a call from the owner of the house that Arbery may be there. So this body cam was shown to the jury. So that's where we're at now. Now the the big question that we're all going to have to solve in this particular case is, number one, the first thing is that, did Ahmaud Arbery terrorize this neighborhood? And if he did, was they looking for him for burglary, which was a felony? If so, then citizen's arrest is on the table. If not, if he was just like everybody else and he was targeted for race, then citizen's arrest is not on the table. So that's what we're looking at now. Hopefully that at least caught you up, because I didn't have a lot of time to catch you guys up. But let's get back to the trial, to watching the trial. But I wanted to at least give you guys an update to where we were at today and the tone of the trial. Let's get back to it.
So the issue of discovery violation.
Oh, so we have some time. So now I can ask some questions. All right. So both trials we're waiting for both trials. So right now they have all these 911 calls. I don't know who has the better side of the argument in this case. I'm just going to be honest with you. Is it the prosecution? Because the prosecution's, they're making it. Oh, my bionic right eye. Yeah. It should be coming out soon. I don't know who got the best argument in this case, because the McMichaels were searching for Arbery with the police, right? The police saw them with guns. It didn't say, hey, put your guns away. What are you guys doing? The police were scared and they thought he might have been armed. Does that fear give you the right 12 days later, if you believe you see the person, to chase them down, to do that type of thing? I don't know. I don't know. That's what the questions the jury's going to have to answer. The fact that the defense is going to be calling all these neighbors, right? All these neighbors to say like, hey, we were being terrorized, right? There were people in this neighborhood who didn't, who this guy was coming into our houses. This guy was doing all this stuff. This guy was doing all these things that were terrorizing us to the point where we were calling the police. And you see that big package of police calls, we needed help. And we put together this plan to try to just detain and catch this guy. The owner of the house did admit, initially he said that he didn't ask anybody to stop Arbery. But they found a text message between him and some of the neighbors that said, hey, if you are on the property, please detain him and arrest him for police. So that's out there. So we have what you've been told about the story, we've all been told. Ahmaud Arbery is a jogger. Ahmaud Arbery was innocent. Ahmaud Arbery was just some guy running down the street, and this was, a killing based on race. That, I think, is now a harder thing to sell to this jury. No, seeing what you have now, seeing the police admit, the people who were on, I'll put the picture up again. I know it's going to be hard for people to see, but I'm going to put it up, because I think it's important. I think it's important. When somebody is in your house, this many times, going into this house this many times, like every month, October, November, these are just the times he was caught on camera, These are just the times he was caught on camera. I don't think it's, the argument that he was just there jogging as an innocent person. I think this is what makes juries stop trusting the prosecutor, because, I don't think a reasonable person would think that he's just in there just, having fun in the middle of the night in somebody else's house, right? Calling a construction site, I think, is a good thing, but it's just, this is a hard sell, right? This is a hard sell. This is what makes him different than the other people. So, Nate, how does the judge charge for multiple defendants? Will they have, they'll have jury instructions for each one of them. You'll see some that applies to all, but you'll see some that applies to some. Nate, the lawyer, what about the law of the first aggressor? Well, I'm assuming you're talking about provocation, like we saw in Rittenhouse, but provocation here would be, their argument is simple, right? The defense's argument is simple. They're saying Arbery was a burglary suspect. We suspect him of burglary. They're admitting, and I think people need to really understand this. The defense has already admitted that they didn't see Arbery come out of the house. They didn't see him go into the house. That the attempted burglary didn't happen in their presence. So that's admitted. That's admitted in opening statements. They said, yes, this is what happened. This is true. We're admitting this. So I want people to understand that point. So they're not saying the burglary happened in their presence. What they're saying is, the burglary, when it did happen, we didn't see it. So I think people, you'll hear a lot of people saying that it has to happen in the presence. They're saying under Georgia law, they don't have to do that. If they have reasonable belief or probable cause that somebody is escaping after committing a felony, right, then they can chase that person down and arrest them. So how does this now deal with this, with first aggressor? Well, if you legally have the right to arrest somebody, let's say, as a hypothetical, Mr. Arbery committed a murder, right? And that murder wasn't committed in their presence. This is a hypothetical, people. He committed a murder, right? And you don't see him that day, but you see him the next day. Is it unreasonable to then, if you have reasonable belief that he was the one that, well, not reason, if you have probable cause that he was the one that committed the burglary, right, or the murder, could you then chase him and arrest him? That's the argument here. Yes, trespassing is not a felony, correct? But they are saying that he did commit it, and they're saying that he did commit a burglary. I don't believe he committed a burglary. I'm saying what the arguments are. Now, a lot of people are going to say he's only a trespass. It's possible, but the defense is making an argument that he was committing a burglary and that he intended to steal, and that they were trying to catch somebody who was allegedly a burglar, and they had probable cause. Now, what is probable cause? I think that's the problem. People think that they have to prove that he was a burglar. No, that's not probable cause. Would probable cause is there enough information that would lead someone, a prudent person, to believe that a crime was committed and that this person committed that crime, right? So in this case, things were stolen from their property, right? Things were stolen from this property. The owner admitted that. This person's in there at night searching for stuff. would you believe if you were able to identify this person, right? The owner says something was stolen. I don't know who stole it, but here's surveillance footage, and this is what came up. Would you believe, right, as a prudent person, that this person is likely to have committed the crime? Not saying he did, but that you can come to the conclusion that he may have committed this crime, enough to arrest him, being with this evidence that you have in front of you. Then Michael says yes. The state says no. That's what we're getting into, and that's the mess that we're trying to uncover. I know it's a lot. I know I'm hitting you guys with a lot. I'm sorry, but this is a very complicated case. It's not as easy as the Rittenhouse case, because Rittenhouse was easy, right? Self-defense. This is very difficult, because if they did have the right of citizens arrest, this jury finds that they had probable cause for a citizen's arrest. Now you're talking about, them being justified in trying to effectuate that arrest. And if that's so, then you got to look at them as almost like law enforcement, right? Now you actually kind of almost put badges and uniforms on them and say they were out there lawfully conducting the citizen's arrest, and this person tried to resist arrest. And just like if he charged a cop who had his gun out, that now you're talking about that scenario. I don't think we're there yet, but I'm just giving you the arguments, the legal arguments. On the other side, they're saying this is nothing but trespass. And to be fair to the prosecution and to be fair to Arbery, the prosecutor has said, the police has actually already said that if we would have caught Arbery, right, after this last day, February, if they'd have caught him on February 11th, they wouldn't have been able to arrest him for burglary. They'd have arrested him for trespassing. And they wouldn't have even been able to, let me change that up. They wouldn't have been able to arrest him for trespassing. They were actually looking for him at this time to give Arbery a trespass warning, right? So in other words, you're on the property illegally. We're giving you a trespass warning. And if you'd have come back, they would have arrested him for trespass, which is a misdemeanor. So the police were looking for him for trespass. That's what they said on the stand. But the defense then countered with saying, well, was this a dwelling? Yes. Was something stolen from this dwelling? Yes. Do you believe that, would a reasonable person believe that the person coming in there all these times at night looking through stuff was the person who stole it? Yes. That's where you get the conflict in law. One instance, he's really, we can't really arrest him for anything but trespass, but another instance, we can resolve the elements of burglary. I know I said a lot. I'm sorry. Let me answer this question. Question 1. What did they have to show of justification to expect that he was armed? Well, right now, what they've shown was the police. The police were the ones who told them that this person may be armed, and the police were the ones who actually searched with the McMichaels. I don't think this point can be understated. The police are the ones that showed that they searched the property with the McMichaels, guns out, because they believe that Arbery was armed. So that's the justification they're going to use to say, yeah, that's the reason why we got our guns, because we thought he was armed because the police told us so. And I'll look for that if you guys want to see that. But yeah, that's what this is. Question 2: was there a burglary? That's the $1 million question. If there was a burglary, because a burglary isn't you stole something. If you can prove you intended to steal something, I got a burglary. So I don't have to actually prove you. And a lot of people in the chat will say, well, he didn't steal anything. He didn't steal anything. Well, that's not the standard. The standard is if I can prove you intended to steal something. How do you prove somebody intended to do something? If you're in there all the time, something was stolen before, you're in there looking for stuff, you're in there looking around, this is not your property. How else do you show somebody? Think, and I throw it to the chat. How do you prove somebody intended to steal something? How do you prove someone intends to steal something, right? If someone's going into someone else's house, looking through all their stuff, is that enough to say that they intended to steal something? I'm just throwing it to you guys. If the jury believes that's enough, right? Somebody's going to somebody else's house looking through their stuff and, in the middle of the night, is that enough? But on the other side, well, he didn't steal anything, and that's trespass. So this is the fight. This is a fight. And I understand the racial issue has this component to it, which I think the prosecution is going to be hammering on. But essentially, that's the question that's going to be answered by this jury. Let me see. So nothing else is going on. Everybody's on recess now. So we're just chilling right now, waiting for either The jury's supposed to be back at 9:00 for Rittenhouse, so we'll wait for Rittenhouse to come back. And this case is going on. So if anybody, let's answer some questions in the chat. If anybody has any questions, the way I'm going to do questions is super chats obviously get priority. So if you put a super chat up in here, I'm going to, your question pops up, you're going to get it. Otherwise, you can tag me and I will look for it. So at Nate the Lawyer, no, the defense counsel does not have to prove Arbery had intent. I don't know if their theory of the crime is burglary, and they're the ones who are asking for the burglary charge to be read. Yeah, they're gonna have to show that it was reasonable for the McMichaels to believe that Arbery had committed a burglary. Right? That's kind of that's where we're at. They do not have to prove they reasonably believe that he intended to steal or had stolen based on his actions. Yeah. That's what they're trying to prove. They're trying to prove a burglary. So that's what they're trying to do. I'm sorry. That's exactly what they are trying to do. If you go look at the opening, if you want to vote for Kyle, I don't know. Kyle Rittenhouse, yesterday's closings were horrible. On both sides, but I think the prosecution really just threw the case away. Nate the Lawyer, when they say armed, is that just guns, or I'm not sure, but they did say armed. I'll see if I can scrub the thing today. And Nate the Lawyer, if Kyle is found not guilty on all charges, then the DA should also drop the charges against Dominic Black. No, they're those are two separate crimes, two separate cases. They're still gonna go with that case. Will anything happen to the homeowner who lied, asking the community to apprehend him? I don't believe so, because he's a very sympathetic witness. This guy is he's essentially dying. He's waiting for a heart transplant. So, he's already a sympathetic witness, already talking about he's scared of the mob. I don't think you prosecute him. I don't think you get a conviction for prosecuting him. I don't think you can prosecute him. Even though he lied, what are you going to do? He's an old man who's on his deathbed. Really? You're going to prosecute him? And Nate the Lawyer, do you have any more information about the escape? So we're back up at the Arbery case. Jury is walking back in. Here we go. So now we're watching the prosecution continue on with its case in chief. They're still going to continue to put on their evidence. They say they will be ending by the end of today. I don't know what they're going to do. I don't know if they're going to be ended by the end of the day, but we'll see. We'll not by the end of the day, by the end of tomorrow. So tomorrow the prosecution ends, and then we'll have the defense. Nate the Lawyer, is the evidence in Arbery being hit with a vehicle? Yes, that's in. That's it. He was hit with the vehicle. They were trying to catch him, but they're trying to say all that was justified. Again, the McMichaels is saying all that was justified because they were trying to arrest him for burglary. The prosecution is saying all that was not justified because they were trying to make a false imprisonment. So all that is relevant to this. And Nate the Lawyer, if Kyle gets off, can he testify for Black 3? I'm not sure. He'd be able to testify for whatever he wants. Thanks for the super sticker. All right. Good morning, old friend. Hey, Dana, what's going on? Long time no see. We'll see. They got the jury coming back. Yesterday, the defense attorney keeps making such a big fuss about Jesse Jackson. It's like nobody else cares about Jesse Jackson being there. Why are you kidding? If Kyle's acquitted, is there any legal route Kyle can take against the state? No, because they have probable cause. It's going to be tough. That's going to be tough. They have probable cause. I think the gun charge was bullshit. Nick called it correct, the gun charge, because but I'm surprised the judge let it go that far. But Kyle's all or nothing right now. If the police had been chasing him instead of McMichaels, were they justified in shooting him? That's a good question, because the police do have to show why they were justified in taking out their guns. If they would have thought that, if they could say that we thought he was armed from our thing from before, with we had our weapons out, I think you can argue for a justified shooting. I think you can. All right.
Good morning.
That's why this is going to be
Welcome
difficult.
back, ladies and gentlemen.
This case has become a lot more difficult than I thought it was going to be.
With the state's next witness. Again, welcome back. Ms. Donikowski, ready to go?
Yes, Judge. At this time, the state calls Dr. Donahue.
So now they're going to go into Kyle's to his injuries and to Arbery's injuries. And yesterday they were doing a lot of this too. They were going into these, these fact witnesses, the forensics people who are doing about, how the gunshots were, the damage to his body, so forth, so forth. We might get a lot of that today, but it's going to be interesting how the state covers this.
About the truth.
I do.
Could Bingham be charged with brandishing a felony assault? But seems like they should. Yeah, right. Pointing a gun at the jury, which is kind of crazy, which is kind of insane. I don't know.
All right, doctor, please state your name and spell it for the record.
Let's see who this
I'm
is.
Dr. Edmund R. Donahue. Donahue is spelled Donoghue.
And what's your occupation?
I'm a physician and forensic pathologist.
Because the state didn't prove it, and actually it was legal.
Pathology is the study of
the gun. Kyle had an illegal gun in Wisconsin.
And what is anatomic pathology?
Anatomic pathology is a subspecialty of the field of pathology that concerns itself with the examination of tissues removed at operations and the performance of autopsies.
All right, so tell us a little bit about your background as both a physician and as someone who's a forensic pathologist.
And straight up, this prosecutor is really good.
I'm a graduate of the University
this prosecutor is
of Notre
amazing.
Dame.
I'm just going to say it. She's really good.
1966 with a Bachelor of Science degree in pre-professional studies. Following that, I attended Marquette, the Medical College of Wisconsin. I graduated in 1970 with the degree Doctor of Medicine.
40 years ago,
Next,
he graduated.
I took a straight medical internship at the Mayo Clinic in Rochester, Minnesota from 1970 to 71. Following that, I took 2 years of training in the special field of anatomic pathology. That also was at the Mayo Clinic in Rochester, Minnesota from 1971 to 73. Next, I took a year of training in the special field of forensic pathology at the Office of the Medical Examiner of Wayne County, Michigan in Detroit. That was from 1970
That's true,
to
50.
74. Following that, I went on active duty with the United States Navy, and I took an additional year of training in the special field of forensic pathology at the Armed Forces Institute of Pathology from
That's a good point.
1974 to 75.
But remember,
And
her
so
witness
what
is
did
the
you
one
do
that
after
said
your
that they were
service
armed.
in the
It's
Navy?
the prosecution's
After
witness.
my service in the Navy, I went to work in the Office of the Medical Examiner
spell it
of
right.
Cook
Thanks.
County, Illinois. Initially, I was the Deputy Chief Medical Examiner, and in 1993, I was promoted to the Chief Medical Examiner, Cook County.
While they do this background on this guy, Rittenhouse is coming in. They're gonna send the jury out. So we'll just watch that. They just send the jury out. So it's nothing big, and they're getting background information on this guy. So let's go check out Rittenhouse and see the jury get sent out to determine whether he's going to be guilty or not. Here we go. So they're all there. So just so already know, we're still watching the Arbery trial, but we're just watching the jury just get charged and go out. So they're going to go out and deliberate. Then we're going to jump right back to the Ahmaud Arbery case, where they have the pathologist, the guy who, how did he die? But we all know how he died, right? He died because he was shot with a shotgun at point blank range. So, oops, let me unmute this. No, it is unmuted. They haven't unmuted on their end. Maybe I gotta look for another feed. Okay. Yeah, that's the one on their end. They are not unmuted. Let me see. Rittenhouse.
Communicate in any way or access any site.
Oh, there it is.
The case. And let's take strike the jurors as necessary. All of the jurors' numbers have been exhibited to the defendant, I believe. And
just so everybody understands.
And then please put them in the tumbler, and the bailiff will rotate it, and then the defendant will draw out 6 of the numbers.
So everybody who understands, there are 18
just,
people in the jury pool.
Separate them.
There are 18 people in the jury pool. They all are now jurors. So what they're doing is having Kyle pick out 6 numbers. Those 6 numbers, those people will go home. The 12 people left are going to be the people who determine whether he's guilty or innocent. And they put it in this box, and it's a lottery. So here's the jury lottery. For those of you who've never seen this jury lottery, but here we go. 18 people on the panel. Think about this, man. This is the lottery for the rest of your life, right? This is goddamn. 17. This is scary. He's picking out those numbers. The 6 he picks out are the 6 that go home. Yeah. Picked out 6. But it makes sense, though, if you think about it. If you know that if you're an alternate, then it's like you won't listen to the trial, right? I'm an alternate. I may not, but if you don't know until the end, then you have to listen to everything. So I think that's the reason why they do it. So yeah, they pulled out 6. So he got the 6 out. Well, that's because they want all the jurors. If you have jurors who know I'm on the jury, then you have 6 who are alternates. The alternates are less likely to pay attention to the trial. So what they do is just say, okay, you're all jurors. And then at the very end, before they deliberate, some people are going to go home. So to keep everybody motivated to paying attention to the trial. Here in New York, we don't do that. You get 12 and then you get the alternates. And if at the end, the alternates go home. You already know if you're an alternate or not. So here, the defendant gets the pick. Yes, Kyle pulled the jury numbers. Yes.
As I call your number, you please stand up. Number 11.
Number 11 is gone.
Number 58. Number 14. Number 45. Number 9. And number 52. And then if you'll follow the bailiff into the back room.
The other bring that back in.
Yeah, Arbery case, he's still talking about his qualifications. Nate the lawyer, you're single-handedly making fools out of the news media with your fact-based advice coming to these 2 trials. Thank you for the news. You restored my face of possession. Thank you so much. Thank you.
Each count in the information.
I appreciate that.
Charges a separate crime, and you must consider each one separately. Your verdict for the crime charged on one count must not affect your verdict on any other. As I indicated, I think yesterday, that you must return only one verdict for each count of the information.
What are we doing?
If you need to communicate with me while you are in deliberation, please send a note through the bailiff, which is signed by the presiding juror whom you've elected. In the event that you have questions, I will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you await an answer. I will answer any questions in writing or orally here in open court. When you agree upon your verdict, have it signed and dated by the presiding juror as to each count, and all of you return with the verdict to the court. Phyllis? You need to solemnly swear that you will keep all persons sworn on this jury together in some private and convenient place, and that you will not speak to them nor permit anyone else to speak to them concerning the state of their deliberations or the verdicts upon which they.
He's swearing in a bailiff.
Okay. All right, folks, you can retire to consider your verdicts.
That's it. It's in the hands of the jury now. It's in the hands of the jury. That's kind of sick, though, right? He had to pick his own. You pick your own, your jurors. That's sick. Woo. Tough stuff, man. It's in the hands of the jury, right? Damn. Nate the lawyer. Do you believe the judge handled himself according during the trial? Yes and no. I think number one, I think this is an awesome judge. I think this judge did a very good job. most of his rules are consistent with his other rulings. This guy's an appointed Democrat, and he's been extremely fair. I think at one point he was a little too trigger happy with the prosecution, but I understand why. The prosecution was definitely trying to make the prosecution, I think, did a lot of things that I personally would have done. I honestly think some of it could technically be unethical. I really am scared to say that because I know the implications of that toward. I do understand the implications of that, but like the gun charge, for instance, they didn't put on any evidence to convict him of the gun charge, right? And on top of that, they just so everybody understands, for the gun charge, the gun has to be a certain barrel length. They didn't measure the barrel length, right? And they wanted this, and they still wanted to send that charge to the jury. And then it come to find out the barrel length was too long anyway, so it was actually a legal weapon. It's like, and then they still wanted to send it to the jury until the judge kind of said, kind of held them to it. So, yeah, that's not good. And the fact that some of these, if they weren't lying, I don't know what you call it, right? So
Shakespeare wrote, "Parting, as they say, is such sweet sorrow." You've been wonderful.
So these are the 6 jurors
and we couldn't have asked for a higher quality jury, better jurors, more
that get to go home.
Jurors, and
but I think the prosecution really did.
With this
prosecution did a horrible job, though, in prosecuting this case for sure.
But then when you take them up, you can take that up to.
I got a lot of issues. I think, I got a lot of. I might be filing a report myself.
Sometimes
if I was in that state.
By their importance, where jurors have been restored to the jury after having been dismissed. So that is conceivable it would happen in this case. It's not likely.
So now they are officially alternates.
Unlikely, but it's possible. So I'm going to ask that you continue with the instruction that you not
as long as they need
the case with anyone.
As long as they need.
The 6 of you can't deliberate at all or discuss the case in any way. You can't read, watch, or listen to any account of the trial. Did some of you bring laptops? No. Well, I feel badly about that because I had a jury some years ago that was just in a similar situation, and the extra jurors were all they had to watch was daytime TV.
To the Ahmaud Arbery trial, because the only thing he's doing is telling the other jurors, like, good luck to you guys, right? You guys got to sit here and look at the walls while the other people make the decision. Yeah, I don't know. But tough day for the alternate jurors. So so we're going to go back to the Ahmaud Arbery trial. That's not the Ahmaud Arbery trial. We're going to go back to the Ahmaud Arbery trial and see what the medical examiner has to say. Day 8.
The distinguished forensic science.
How long were his arms?
Okay, so now we're going to Ahmaud
And how would you describe the condition of his body?
Well, he was muscular and thin.
And how long were his arms?
His right arm measured from the.
Now, before we get into the body measurements of Ahmaud Arbery, I just want to let everybody know we're hot watching the Rittenhouse trial. So if they go to verdict, we're going to verdict, right? We're going to go there and watch the verdict. So I'm assuming we got some hours because they got to, just so everybody understands, they got to go in, they got to vote to see who's going to be the foreman. Then they got to go figure out. Now, generally, the way it works in a jury room is that what they'll do is you have the 12 people and they'll say, okay, let's take an initial vote to see where we're all at. If they all are at not guilty, done, and we're going to get out of there. Sometimes you might have 1 or 2 guilty, then they got to talk it out, right? Why do you feel guilty? Why do you not feel guilty? Let's see until they get a unanimous verdict, right? Now, sometimes if they don't do that, this can stretch on for months, and then eventually they'll go to the judge and say, we just can't do it. It's just we're deadlocked. Then the prosecution gets another bite at the apple. So that's where we're going right now. They're in the jury room. They're probably voting to see who's going to be that, and then we'll see what happens. I'm assuming if everything I've been reading, I'm hoping it's today or tomorrow. It may not be. I felt Chauvin was going to come back quick, and it did. I'm assuming these jurors are going to come back quick. So, but we'll see. Well, the juries are strange to say the least. So we don't know what they're going to do.
Axilla, or the armpit, to the first joint was 26.1 inches, and the left arm measured from the armpit
Yeah.
to the first
Don't
knuckle
bring your
was
laptop. I hope you brought your
25.3
laptop,
inches.
but don't look at nothing.
All right. Now, before we get into the actual autopsy, I want to ask you about your experience with motor vehicles and their ability to cause serious bodily injury to someone when used offensively. Have you had any experience with that?
I've had experience with, yes, motor vehicles.
Obviously, they're talking about them hitting Ahmaud Arbery with the car.
So taking you to the autopsy of Ahmaud Arbery, you mentioned that
go.
part of the autopsy is to take photographs. Is that correct?
That is correct.
And were photographs taken in this particular case?
Yes, they were.
All right. Prior to coming in to court today, did you have the opportunity to take a look at State's Exhibit 2 through 23 and then 25 through 38?
Yes.
All right. And were they fair and accurate pictures of the autopsy of Ahmaud Arbery that was conducted on February 24th of 2020?
Yes, they were.
All right. At this time, the state would tender into evidence States 2 through 23 and then 25 through 38.
No objection.
No objection, Your Honor.
No objection.
Now, I want to make sure, when you first did your autopsy report,
They may come back this morning for
were
all we
you
know.
given any other evidence, meaning the homicide video or the frame by frame of the homicide video for your review in conjunction with your autopsy report?
I was not.
All right. So you were just told, perform an autopsy on this young man without any real other evidence to review.
Yes. Could, Your Honor, could I have a glass of water?
Yes. We have.
Yeah, I got
Couple different people running in
locals, I
different
got
directions. Looks like
PayPal. It's
we've
all in
got
the
some
description.
traction over there.
You can check it out.
Thank you.
Sure.
It's all in the description if you would like to. Thank you, though, too. Thanks for the question.
So
This guy's old school, too. This
I'm
guy's
sure
like
she'll
40
bring you
years.
water in a moment.
That's
So-
fine. We
This
can continue.
prosecutor is a great
So when
if
we're looking
she was
at
in the Rittenhouse
State's
trial, I think
Exhibit
there would be a problem, right?
2.
He's like, "Yeah, this is not going to be an easy one." Can a motion for mistrial with prejudice
What is the
be
jury looking at
described
here
after the jury
in State's
deliberates?
Exhibit number 2?
Yes,
State's
and
Exhibit
it's
2
called
is
it's
the
with the
legend
JNOV
board for
judgment
an
with
autopsy case in
judgment
the
notwithstanding the
medical examiner's
verdict.
office. It has the
So the judge can disagree with the jury.
Coastal MEO, that stands for Medical Examiner's Office. It has the date. Thank you very much. February 24th,
Yes,
2020.
I believe the
And
Rittenhouse
here's
prosecutor was
this,
trying to get a mistrial because the case was so
individual
weak, and
case
when
number
and we
that's
wasn't able to get it,
assigned to every
they
case
tried to
for
just confuse the
purposes of
jury.
photographs
So yes, I
and
believe they were trying to get a
evidence
mistrial.
control. So the case number was 2020-600-1183. And any pictures that are taken will have that case number in it. And any
Yes,
evidence
I'm still
that's
practicing
taken will be labeled with that
My
number
last
so that they
case
can keep
was
track
about
of.
3 months
All
ago.
right, so the Coastal Medical Examiner's Office, that's not like a local Glenn County.
Oh, matter of fact, no,
medical examiner,
I
right?
lied. My
No,
last case was like actually a
we
month and a
actually,
half ago.
the medical
It's a criminal
examiner's
case,
office for
but
about
I'm not going to talk
25
about it
counties here in
because
southeastern Georgia.
it's still ongoing,
And
unfortunately.
is the medical
So yeah,
examiner's
so
office
I have
part
an
of the
active
Georgia
criminal
Bureau
case
of
that's
Investigation?
going on.
Yes, it
It's a
is.
pretty big case too.
So that's
You guys
the
might see me
related
in the
Georgia
news
Bureau of
again. So
Investigation
if you
you'll see at
do,
the bottom.
you'll know.
That is the, case number,
Yeah,
yes.
I got another
All
case
right.
that might
So
hit the
when
news.
the jury is
I'm hoping it
looking
don't.
at
I'm hoping it don't.
State's
But
Exhibit number 3, what's the jury looking at here?
This is an identification photo of Ahmaud Arbery.
And when we look at the identification photo, is this taken so we know who this person is?
Yes.
Now, when
So
we look at
YouTube
this
doesn't
page here,
destroy this
have some
stream. I gotta
things
look
here,
to make sure we don't
here,
have
and
too much
here.
madness with
In
here.
your medical body,
Oh
Yes.
yeah, you got some madness coming up.
10.
All right, I don't want to show.
We're looking at states 10. What's
the
the jury
problem.
looking at there?
All right, so this is the problem with the stream as it is now. I don't want to show you all that gory stuff. And the reason why is because YouTube is going to kill me, right? They killed my other stream. They just glanced at it, right? They showed the Ahmaud Arbery being shot. It was a glance. I killed it. 17 and all this other stuff, and give me a warning. So I don't want to get suspended from streaming. So what I'm going to do, because I know none of you saw this, let's go to the cross-examination of the homeowner. So you guys can be caught up to what happened, because obviously we know how he died, right? Obviously we know how he died, but I would rather have you guys caught up on what actually happened in this trial and why I believe this trial is not going that well for the prosecutor. Now I know I thank you for the super chats, but I don't want this stream to be removed because of this crazy content, and they did it to me already, right? They already gave me a warning, and I don't want to get 7 days in the hole. YouTube is going to kill me with that. So I'm going to go back to the homeowner's cross-examination to show you all the lies that he told, all that stuff, and so you guys can be in a better place, because I think that would be better than this, right? It'll be more informative than this. And again, for those of you who are waiting for the trial for Rittenhouse, when Rittenhouse comes back, we're going back for Rittenhouse. So let me go back to this. I should have been prepared for this, but I want to make sure you guys. Is it this one? No, that's me. So I'm gonna go back to this other, in another earlier Arbery trial. If you guys have any questions, you definitely can let me know. I don't want the live stream. Let me get the other one that I just saw. I want the homeowner. Only the homeowner. I'm just looking for his testimony. All right, here it is. Found it. So I'm going to move this. This one.
Google Meet.
So this is the property owner.
Yeah.
Cross-examination.
She doesn't work for the prosecution. Is that correct? Not that I know of. She is related to your wife? Yes. Your wife's name is Amy.
Now this is going to be hard to hear because this was pre-recorded. I don't know why well, I do know why they did it this way. The reason why it's pre-recorded is because he's too sick to testify now. So because he's too sick to testify now, they took his testimony months earlier, and he was both direct and cross-examination. So you're going to see the cross-examination, which I think is more important than the direct examination, because he's a prosecution witness. So listen to this.
And then, of course, nothing can be more stressful than what you went through after the shooting of Ahmaud Arbery. Yes. Right? It affected you personally, correct? Yes.
I know this is low. I'm very sorry.
Times in the months following the shooting where you yourself felt like you were in danger of being killed.
This is the homeowner being cross-examined by the defense attorney. He's in need of a heart transplant, so he's a very sympathetic witness.
You were going to be killed. That's what I was told. You actually had to call 911 on multiple occasions because you felt harassing.
This is the audio from the court. It's all low. I'll see if I can find another feed.
And that caused a great deal of fear in you and your family. You weren't sure you were ever going to be able to use your property as a killer again. There was a point when I didn't know. You were scared for yourself. You were scared for your wife, right? Yes. You had 2 children below the age of 18. You were scared for them. Yes. You were even so fearful, you worried about a drive-by shooting as something that was potentially possible. Yes, I've had those thoughts. And as a result of that, you have taken it upon yourself, with the aid of Miss Grady, your wife's cousin, to talk to the press, right? Yes. And try to explain your actions, even though you weren't ever charged with anything. Right. You felt like you yourself were being accused of something you felt like you never did. Yes. You didn't have anything to do with the shooting of Ahmaud Arbery, right? You were a homeowner whose home just happened to be the home that he entered upon. Yes. And when this thing blew up, you yourself became harassed, right? Repeat the question, please. When this thing blew up, when the social media and the national media all of a sudden started covering the case, you yourself became a target.
Yes.
Of people harassing you.
People were harassing him. What are you saying? People were harassing him. People were following him. People were protesting in front of his house, scaring him.
Beth?
Yes.
Reached out to me, the best I remember, Beth reached out to me and explained that I was going to need some help.
Okay. And you were grateful for that help?
Yes.
And she has, in fact, helped you interact with the press, right?
Yes.
Interact with investigators, right?
Yes.
Interact with me.
Yes.
Right? You remember we had a Zoom call about 1.5 years ago.
I don't recall that, but I'm sure we did.
And Ms. Hogue was on the call. You remember that?
I don't remember. I don't recall it.
Okay, you don't disagree that we had.
No, I don't disagree that I don't recall it.
And your memory, there's some effect from your illness, I take it, on your memory.
I'm sure everything I went through for the last 6-7 years affected it.
Okay. Now, Mr. English, you, on the day of the shooting, you found out about the shooting from Diego Perez.
Yes.
Okay. And did you talk to Glenn County investigators on that day or within a couple hours of that day?
Not that I recall.
Do you know if you talked to them the next day?
I don't remember.
You're not saying you did, you just don't remember.
Exactly.
Okay.
He's being very evasive, saying he doesn't remember anything, right?
A couple GBI agents. Do you remember that?
I did. I talked to GBI.
You mentioned one, Seth Hollander. You don't remember that person by name, but you do remember meeting with GBI agents.
I remember meeting with 2 or 3 different ones.
Okay. You met with one, and I can refresh your memory.
This is not me. This is the court's audio. So I have it as high as I can on mine.
May 6th,
Sorry.
2020. Does that ring a bell?
No.
If I showed you a transcript and let you read a couple lines, might that refresh your memory?
Probably.
Yeah, Your Honor.
This is from YouTube, so that's why it's so low. Sorry about that.
And I don't want to cause any concern. How do I approach Mr. English?
Why don't you do this? Why don't you just pass it here, I'll pass it around.
Now remember, just so we're all on the same page. Mr. English has testified on direct that Mr. Arbery was not a bad guy. He was, model citizen. He just was around the neighborhood a couple of times. He was not really a big deal, and he wasn't really concerned about Mr. Arbery as a threat. So the defense attorney is trying to probe that and show that he's lying.
A few lines of your conversation. See if that refreshes your memory of meeting with Mr. GBI agent Hollander.
You want to read it out loud or you want to read it?
Just to yourself, just see if it refreshes your memory, because I know it's a long time ago.
Yeah, I'm bringing my mic level down so it won't blast you guys in the ear. Sorry about that. If you guys can hear me still. I'm bringing my mic levels down, but he's reading a statement that he said before that he says he forgot. Mr. English is the homeowner that the prosecution, that the prosecutor is bringing forward, saying that Ahmaud Arbery was not a problem, and he was not a threat, and he was not concerned about Ahmaud Arbery. So that's what we're looking at now.
Does that refresh any recollection, Mr. English?
I remember having some of that conversation with somebody, but I don't know exactly who it was.
Okay. And you wouldn't disagree with me if I told you that conversation took place on May 6th, 2020, right?
If it took place, I can't tell you what day.
Okay. Subsequent to that date, you called 911. You remember calling on May 8th, 2020?
No.
You remember calling about a man in a maroon Jeep with custom wheels walking around your home?
No.
He's going through all his 911 calls.
Report, refresh your memory.
I don't remember the.
Okay. You remember calling again on the 9th, and complaining to the dispatcher.
This isn't my computer. This is the court playing back a recording to the jury of his testimony.
People driving up on your property. And
yes, you can lead the witness on cross-examination. He's on cross-examination.
I know the day of one of the protests, some people went in the yard with a motorcycle and they cut some donuts, and then there was also some people walked up to the front door and looked in the windows.
Did you call 911 once you noticed that they were on your property?
I may have.
I know. This is crazy.
And you also, in fact, had a recording of you holding your cell phone, and on your cell phone, you were watching the protests in your neighborhood. Do you remember that?
No, I'm not going to say I did, but I don't remember.
You remember watching the protests in your neighborhood?
I watched them walk by.
And to tell short, you were watching while they walked by, and this is when the man said you're going to be popped.
Yes, that particular day, I had HVAC guys there.
Someone threatened him, saying that he was going to be popped. So he's told him, so he's building up the fear, that how much fear he had. You know, why he's telling these stories. Because he's afraid, see?
It was pretty frightening.
I couldn't understand.
It was pretty frightening.
Yes.
Do you recall calling the police again when trespassers were turning water on and off on your property?
I don't remember. I don't remember having any issues with the water, not that I know of.
We're looking at your call detail report. Refresh your memory.
Yeah. If you ask me that, I'm going to get me look at it.
Only if it would help refresh your memory.
It won't help. I can't remember. I apologize.
That's okay. When did Miss Grady call you to talk to you about helping you?
I don't even remember what brought it about. I don't know if she saw it on TV. I don't know how she found out about it or what brought it on.
Well, after your first meeting with the GBI, you had a second meeting with Agent Seacrest on the 15th of May.
When I discovered fiber optic, it was just kind of a gift.
Hit me with an ad.
I'm Elma.
Correct.
Just so let me stop this. Just so we're all on the same page. This is the Ahmaud Arbery case, and this is the owner of the home who had previously testified on direct examination that Ahmaud Arbery was not a threat. He was not a problem. Now he's being cross-examined, and they're going through all his, not like he's made so many 911 calls, messages, all this stuff. So they're going through that to show you that they're impeaching him. Now, he was unable to testify live, right? So the reason why he's unable to testify live is because he's sick. He needs a heart transplant. So this testimony is from 2 months ago. So we're watching the recording of both his direct and his cross-examination. So this is a cross-examination we're watching. That's the reason why the volume is so low, and that's the reason why it's a little tough to hear. So I'll play a little bit more of this, but you'll get the issue, because right now, as we can see, he is scared. He's been saying that I'm scared because somebody threatened to pop him and cap him because if he says the wrong things in this trial. So the defense attorney is playing it to let people know what's up. Please go back to the actual trial. We've already watched this with you. No, you didn't watch this with me because I never played this. But I can't go back to the actual. Now, the reason why I'm here, and I'll go back to the actual trial, but the reason why I can't go to the actual trial now is because they're going through the gory details. And YouTube is going to cut my stream, as it has done before, if we start seeing, Arbery's gunshots with an open body. So when they start playing, after they finish with that piece, then we'll go back to that trial. But I can't do it because they're going to cut my stream. That's the reason why we're not watching the trial live, right? They just if you're NBC or something, they're not going to cut you, but they have cut it. They've done it before with a couple of these cases. They did it with this Arbery case. One of my streams were cut before my last Arbery stream that had the gory pictures they cut. So I'm just being abundantly cautious because I did you the warning. So that's the reason why. I'm sorry if you guys want to watch it live, but we didn't go over this, so that's why I'm playing this again, so we can at least hear what happened. But I am keeping my eye on the actual stream to make sure.
They were requesting my wife's phones, and maybe she was supposed to download the information that was supposed to relate to this rather than taking all the information.
And in that meeting with Agent Seacrest is where you walk through with the agent where your boat was at different times. Does that ring a bell?
I could have, I mean, I've told so many people the story out here, I don't remember that.
Well, let's go back then to the beginning of all of this for you.
Okay.
You testified earlier that you bought the property, I think 4 or 5 years ago.
Somewhere on there.
And about a year later after that, you started building your dream house, your vacation house on Satilla Drive.
Right.
You're gonna live on the water, or at least have use of a house on the water, Satilla River, and enjoy that as you got a little bit older. I know your health was a concern at that point, right?
Yeah.
Initially, you had, I think you said 2 cameras out there, or 3 cameras out there?
They come in a.
Move forward a little bit.
I can't remember.
Can I hand you a pen?
Yes.
Okay. The backyard was.
So I'm just moving forward a little bit.
More detail, but eventually you added 7 more cameras. If possible.
They're going to where the cameras were at on his property.
At this point, I would tender to evidence Travis McMichael exhibit number 2 to show where the photograph, where the cameras were located. Okay. All right.
To the best I recall.
Fair enough. In going through all the videos that you watched today, cameras at the dock, cameras in the back of the house, cameras in the front of the house, at no point do you see anyone stealing any items, right?
Stealing anything?
Correct. At no point do you see someone carrying out of your house items that belong to you.
No.
And yet you know that items are missing from the boat that was parked in your house, right?
Yes. Well, now, I don't know for sure if it was in the house when it happened. I don't have video, and at one point I assumed that it happened at the house, but I can say it for sure happened at the house.
And as we sit here today, you don't know where the items were taken or who took them.
No.
But at the time, and I'm talking about October, November, December 2019, January and February of 2020, you knew items were taken, you knew the boat had been parked in the house, correct?
I knew the boat had been at the house at one point, but I had also moved it back into the Douglas multiple times.
Right. But you knew the items were taken, and you knew the boat had been parked at the house, correct?
At one time it had, but I don't know the items were taken while it was at the house.
But that's not what you told the police, is it?
I don't know that.
Okay, we're gonna walk through it now.
Okay.
The state showed you a video of children coming into your yard during the
If you notice, that's not what you told the police.
Yes.
Are those Subi Lawrence's kids, do you know?
Is it what?
Are they Subi Lawrence's kids?
Yes.
Okay, so Subi
Looking
Lawrence.
at the video, I assumed that that's what she is.
And you know Subi as the woman who lives across the street, who has 2 boys, right?
Or 3.
Or 3 boys?
I think so.
Okay. When did you meet Subi?
I can't recall exactly when. As already was stated, there are multiple mailboxes there. One of those mailboxes is hers, and when she stopped to check the mail in the evening, one evening, I think when there, she may have introduced herself, but I think that's how it came about.
But the video depicting the boys coming onto your property, that's not the first time you saw people coming on your property, right?
Probably not. I don't know.
The first time you saw someone coming on the property was at night, and it was that first 911 phone call.
Yes, on video, yes.
You didn't have any problem with those boys coming on, right?
No.
It's daytime, and boys will be boys.
I knew who it was.
Better for them to be playing in the street, like you said, than on video games.
That's the way I feel about it.
You didn't have a problem with gawkers in the neighborhood coming to look at your new house, right?
This is important, people.
You didn't have a problem with gawkers in the neighborhood.
Gawkers?
Let me use a different word. People who were curious about your new construction. As long as it was daytime and they were just not hurting anything, you were okay with it.
Not really okay with it, because the time we live in, the liability is so great, and there's so many attorney's looking for a liability suit. So I really don't welcome it, but it's not out of the ordinary.
Kind of comes with the territory of building a house.
Yes,
And as a contractor, as you testified, that's fairly common.
yes,
It's different when someone comes on your property at night.
yes,
It's scarier.
yes,
You don't know why they're there, right?
right,
You don't know what they want.
no,
You don't know if your valuables will still be there in the morning when you come to your house.
right.
It's pretty scary. Let's go to October 25th, 2019. That's the first time you called 911 because of something you saw on your cameras, correct?
The best I remember, I'm not sure about the date.
That's the first time you actually interacted with Officer Rash. Is that true?
I'm not sure exactly when me and Rash had our first conversation.
Their surveillance videos to see if he might have been captured on.
I know I'm muted. The stream didn't allow me to mute. I see it. I see it. Here we go.
Had video that. So yeah, no, I didn't ask anybody to review.
So this is Officer Rash now. So remember the last thing he said was, "Did you speak to Officer Rash?" So this is Officer Rash now, and this is the part when he took the McMichaels on an armed expedition into this man's property to look for Ahmaud Arbery. And that's what we're watching now.
The next time you go out there is February 11th.
Yes, sir.
And
So
February
this is the
11th is now your third time responding to Larry English's house.
I believe so. Yes.
You're aware though that that other officers have been to Larry English's house, right?
Yes.
Are you talking to these other officers?
I have interacted a couple times, just passing on, like at the end of our shift.
Now, for those of you who haven't seen this, this is extremely important in this case, what he's about to say. So please check this out. If you guys really care about the facts, this is just so we understand, this is the officer who's been investigating the Ahmaud Arbery case for about 6 or 7 months. And this is when he's going to take the neighbors on an armed expedition into the house to look for what he believes is an armed man.
Those officers who did respond to Larry English's house on the 17th of November.
I believe so, yes.
Right? When the white couple came to his house, you didn't respond to that call?
No, sir.
Is it your understanding that Officer Powers responded?
I'm not 100% sure. I had to look at the CAD log to see who was on duty that day.
All right, but if you don't have any knowledge, that's fine. February 11th, this time it's not Larry English's call. It's Travis McMichael's call.
Yes.
Were you aware when you got there or on your way there that the man who is now seen on the 11th of February is possibly armed?
This is the highest the volume goes for
at
this
one point,
thing.
Travis said
Sorry.
that he appeared to reach.
This
for
court
his
has
pocket
bad
or his
audio.
waistband.
I've looked at 3 of
I
them.
do not recall if that was relayed to me via dispatch while I was en route or once I arrived on scene.
Okay. So we saw a video, and this time you're not just going in with your flashlight. This time you got guns drawn. So does that help refresh your memory? It does. Of when you heard that the man in the house is possibly armed?
Yeah, I would say yes.
And what does your memory now tell you is when you learned that he was possibly armed?
We went in with our guns drawn based on that. The dispatch told us that he was possibly armed. That's why we would have went in there with our guns drawn while we searched the residence.
So this is a different situation.
So you heard
You're
that.
now going to a house and you might encounter a man who has a gun.
Yes.
Heart pumping?
Yes.
Adrenaline flowing?
Yes.
Okay, now you got to be really on your toes.
Yes, but listen to this testimony.
And we saw another officer with you.
He responded to the house that they believe Arbery might be in,
Officer Sherman.
and they got guns drawn, and they're nervous. They think they're going to see somebody with a gun.
Did you hear Officer Trenton say, and I'm just using the quote, if I misquote it, tell me, where you at, motherfucker?
I don't recall hearing that.
Okay. At this point, though, you're on heightened alert.
Yes.
You have, when you get on scene, you have neighbors out there. You have Travis McMichael out there.
Yes.
Who you hadn't met up till that point.
No.
You have Greg McMichael out there.
Mhm.
And again, you have Diego Perez out there.
Yes.
You recognize Diego as the guy you saw on the 18th of November?
Yes.
You got Officer Sherman with you, or does he come later?
Officer Sherman arrived after. That's why I stood by the car out front waiting on him.
Okay.
He and Officer Chandler Smith, they arrived about the same time.
Okay, and they're your partners. They're your backup essentially.
Backup.
You're taking the lead on this.
Yes.
Okay, and when you get there, essentially, Travis McMichael, Diego Perez, and Greg McMichael are keeping an eye on the house.
Yes.
Okay, making sure that if this guy goes anywhere, this intruder, that they keep eyes on.
Objection. Overuse of the word intruder. And Judge, we would object to that use of that word.
Burglar?
So, ladies and gentlemen, as I've already instructed you, the questions asked by lawyers and statements made by lawyers are not evidence in this.
So I'm just so now you guys are seeing what I saw, right? The police are scared. They thought he may be armed. They went with guns out. His heart was pumping, right? This is what the police are saying about what happens when they were going to search for Arbery. And then they had the neighbors watching the house to make sure.
3 neighbors have basically blanketed the front and back of the house to keep an eye out for this guy. Right?
Upon my arrival, they were all in the front yard.
On the front, okay. At what point do they start going in the back?
I don't recall them going in the back while we were clearing the residence.
Well, you're told Travis is in the back at some point, aren't you?
That's after we walked back to the front, after we cleared the residence, I believe.
Okay. All right. If you'll go start the video. This is no 2. States Exhibit 231. Let's walk through this video a little bit. Yes, actually, if you don't mind, Mr. Jackson. Do you mind, Your Honor, if we pass this?
Okay. You're going to refer to a specific portion of the transcript just at this time?
We're going to walk through the exhibit again.
Okay. So, ladies and gentlemen, if we could, you're going to get copies of the transcript. Don't start reading back over. Mr. Rubin's going to be referring to portions of the transcript, and those transcripts are being given back to you.
So now you're about to see the search. Remember, they're searching the house to see if Ahmaud Arbery, who they now know is Ahmaud Arbery, is in the house.
What's being said versus
right?
what's being seen, so we
The
don't
cops
have
have already told everybody that he may be armed. So now they're going with the cops into this house armed to look for who we now know as Ahmaud Arbery.
This point is Diego Perez.
Yes.
He's got a flashlight.
Yes, sir.
And he's heading towards down the side of the house. Is that correct?
Yes, to the side, yes.
Okay. Now the side of the house, that white.
We're still waiting
vehicle,
for them.
For that white item, that's Mr. English's camper.
Yes.
Okay. Let's stop there. At that point, Officer Rash, had you authorized Diego Perez to do any investigation?
I have not authorized him.
Have you authorized him to do any search for Mr. English or for you?
No, I have not.
You had not deputized Diego Perez.
No, I have not.
But he's out there assisting.
Yes.
You're okay with that?
At that time, yes.
You didn't have any problem with that?
No.
And Greg McMichael and Travis McMichael are out there as well?
Yes, they are.
You're okay with that?
Yes.
You even find out Travis is armed, right?
Yes.
You're okay with that?
Yes.
You didn't tell Travis to go put his gun up?
No.
You didn't tell Travis to go home?
No, I did not.
You didn't tell Greg to go home?
No, I did not.
You didn't tell Diego to go home?
No, I did not.
They're out there keeping their eyes out, assisting you.
Yes.
That's huge, people. Just to understand what we heard, that's huge, right? He knew they were armed. They were out there assisting him, and they went and they're armed. The police are armed because they thought the person who was doing this was armed, was dangerous, right? That's huge. I understand. I understand people are sensitive about this case, but this is the police officer who was doing the search, who was leading the search. And this is 2 weeks before Ahmaud Arbery was killed. Love, you're curious. Would your colleagues in the chat sing the tune if this case were going well for Rittenhouse? Some of it feels bad faith. I'm not sure. Would sing? I'm not sure. I got to think about that question. Let me get back to this.
You're okay with that?
Yes.
So he's okay with them having guns and searching for Ahmaud Arbery. This is what the news media is not telling you. I'm telling you what the news media is not telling you. The law enforcement believed Arbery was armed, and they had regular citizens assisting them in searching for him.
Flashlight
Court audio's low. Yes, I know.
back here.
Yes, sir.
Do you know who that is?
That's Diego Perez standing along the fence, shining the light back there.
Okay, so while you're in front with other officers, your body camera is now just turning on. He's out back. He's heading back by the camper and back where the dock is, correct?
He's walking down the side of the house, yes.
Okay.
The owner of this house has caught this guy on video.
Oh, yeah, I know about that. Yeah, he's called him several, and I'm surprised he hadn't called me tonight.
All right, stop right there. Larry English didn't even call you that night until you called him.
Correct.
Right? Is it your understanding that instead of calling the Glenn County Police, he called Diego Perez?
I did not know that.
Okay.
At that point, I did not know that.
Well, I'm sorry. Go ahead, say that again.
At that point, I did not know that.
When did you find that out?
When on the phone, he told me he had sent the video to Diego, and that's when I responded, I'm the one on duty tonight. I understood him. He sent it to an officer we have, Del Torre, Diego Del Torre.
911 call. It was 911 came over and said the black intruder who may be in the house may be armed. That's what caused them to believe he was armed. But remember, it wasn't just him. It was everybody. All the neighbors who were there searching for him started to get armed up. They were like, yo, if this guy's armed, we got to be careful. And you'll see him with the gun. You'll see it in a couple of minutes where they had their guns out looking for him. So it's the police who gave them that. I think gave them this out. Well, they didn't think it was pointless. They had their guns out, right? They go and decide they're armed.
It looks like
A flashlight. That's out of my front door. I have my standard police issue flashlight, and then I have a larger. It's a brighter flashlight, and my police issue flashlight was going dead, so I went and retrieved a second flashlight.
Okay. And while you're retrieving your flashlight, we see two gentlemen on your body cam. I think you've identified the man in the blue shirt as Diego Perez. And do you know who that is?
I believe that's Travis or Greg McMichael.
The man in what looks like a gray short sleeve shirt.
Yes.
Okay. And he's walking around the house as well.
They're in the front yard of the house. Yes.
Okay.
And also, they're armed. People have to understand they're armed because the police thought, everybody's armed, so we're going in armed.
They were watching. They said unless he's jumped the fence and went over somewhere, they don't know if he hasn't check everything.
Stop right there. That's you.
That is me.
You got your flashlight in one hand and your police issued firearm in the other.
Yes.
Okay. Guns drawn.
Yes, sir.
Okay.
Benton County Police, anybody in here?
Let me stop for a second.
So I'm going to just stop it while I say this. So they're in the house looking for who they believe is Ahmaud Arbery, right? Let me, I got to show you this on February 11th. So just so we all are understanding where we're at in the situation, until we come back, I have to actually go to another screenshot. So we all on the same page, because I want you guys to really get a feel for the evidence and understand what the defense is trying to show you. Here it is. So on February 11th, which you should be seeing on your screen now, if I did it right, February 11th, for on the far right-hand side, this is the picture that the homeowner got of somebody entering the house. Now, we all know all these pictures are Ahmaud Arbery. This is what they're responding to. Police then over the 911 call found that this is February 11th one. They believe that he was armed. The person who's in the house is armed. So they're going now to search. So what we're watching is the police reliving the fact on his body cam when they went to search for Ahmaud Arbery. The police are armed with guns searching the house. So they're in the house now, armed with guns, with flashlight in one hand, gun in the other hand, searching. So are the McMichaels. The McMichaels are also armed, and so is another neighbor. His name is Diego Perez. He's also armed. And they're searching the property because they believed Ahmaud Arbery is armed, and they're looking for him right now. That's what's going on. So I just want to make sure everybody is understanding what we're talking about, why they're there, who they're looking for, and why they are all armed. Citizens and the police. Okay? Going back.
You got your gun drawn, but it's a burglary or trespassing. It's a property crime. So why is your gun drawn?
I believe at that point then we were notified, I guess dispatch had notified us that possibly armed.
So it's for your protection.
My protection.
Not to hurt anybody. It's to protect you.
Absolutely.
In case somebody jumps down from the rafters we're looking at.
Yes, sir.
And surprises you.
Yes, sir.
You need to protect yourself.
Yes, sir.
You need to protect Officer Sherman.
Yes, sir.
You need to protect Greg McMichael, Travis McMichael, and Diego Perez, because they're in danger too.
Possibly.
You don't know what's going to happen.
I do not.
But you don't take any chances.
Not at all.
Okay. So it's standard procedure when you go into a possible armed situation to make sure you have your gun ready.
Yes.
For your protection.
Yes, sir.
Clear here.
Can you stop right there? I didn't hear you, Officer Rash, say, and maybe I just missed it, Glenn County Police, come out, like they do on TV. Did you say it and I missed it, or you didn't say it?
I said Glenn County Police when we walked in.
Okay, so that's to announce your presence.
Yes.
And that's to make sure you're not surprising anybody.
Yes.
And it's to make sure that that person knows if that they should come out because you're an officer.
Yes.
You use your presence to get compliance with orders.
Yes.
Right? You're in uniform. You want them to see your badge, right?
Yes.
See your vest if you're wearing a vest that night that says Glenn County Police.
Yes, sir.
Because presence is one way to gain compliance, right?
Yes, sir.
Shouts is another word. Shout meaning I'm here.
Yes, sir.
I want you to come out with your hands up. That's gaining compliance, right?
Yes, sir.
Okay. Are you familiar with the phrase shout, shove, show, shoot?
No, sir.
Okay. You're familiar with the use of force continuum?
Yes.
And the use of force continuum, as you know from your training, is the levels of force that can be used by a police officer.
Yes.
Including just your presence is a use of force.
Yes.
When I'm here and I tell you to do something, you do it just because I'm here.
Yes.
Another way to get compliance is shouting a command.
Yes, sir.
Do as I say. Because I'm telling you, as a police officer.
If they think somebody's armed,
right?
hand-to-hand
I
combat
get
doesn't
far
work,
better.
right?
Yes.
Another way to gain compliance is to show your weapon as you're doing here.
Yes.
I have a weapon, don't do anything stupid. Here it is, you're not hiding it, right?
Yep.
It's not a concealed weapon. You want them to see it, right?
Yes, sir.
Because seeing a weapon will gain compliance from the person you're seeking to investigate.
Yes, sir.
And then last, of course, the ultimate use of force is shooting somebody.
Absolutely. Yes, sir.
And that's deadly force.
Yes.
And you only do that when you yourself are in danger or when other people are in danger.
Yes.
So before we go back to the search, just so we could all be on the same page, right? This isn't good for the prosecution, right? The police are saying, yeah, we thought he may be armed. Yes, we went there armed. Yes, we had the McMichaels, right? The people who are on trial for murder now, we had them armed in this house looking for the person who they allegedly killed, who we know now know as Ahmaud Arbery, right? We believe he was dangerous. And this whole protecting property is like, you're not protecting property, you're protecting yourself, right? That's the reason why you went in armed. So this is damning testimony. Nate, does the suspicion of burglary really matter for the days he was shot? Well, again, if they can show that he committed a felony and they were trying to arrest him for that felony, then yes, it does matter. I'm considering there's no evidence with which one could be charged with it by police admission. It's interesting because yes, they go over that in this testimony, which you'll see that yes, they can satisfy the elements for probable cause for burglary because that's what you would need, probable cause. So they do go through this, and you'll see the little kerfuffle after it. But somebody stole something from a house, it's a dwelling, and you got this person. Police admitted that Arbery was technically, if you want to talk technically, a burglary suspect. Or this person who they don't know if it's Arbery or not. They don't know the person's name, but that's why. So yeah, this is not looking good.
No, it's just an attic. They don't have there's a ladder here, but to access that attic, but.
You can see him. You can see his gun with the flashlight sometimes. From time to time too.
Is that Officer Sherman?
That is Officer Sherman.
Okay.
Right here now. Doing this next room. Maybe on the dock in the boat or something.
See, Sherman's got his gun out. He's got his gun out looking for him, right? You see, they're not going in there looking for somebody who doesn't have it. He's got his gun out, yes. Right?
You already checked the doors on this camper? See, he's got cameras out here, and the guys caught him on before out here messing around on the boats and stuff.
Who are you talking to?
Officer Sherman.
Okay, so you're getting him up to speed on the things that you know that the guys caught him, the guy being Larry English,
Yes.
caught him out.
I would suspect so, but I don't know the laws in Georgia.
Messing around on the boats and stuff. You're talking about the stuff in the back of the house.
On the docks, yes.
On the docks, okay.
Don't forget, this is they are going out there looking for him armed because the police told them that they were armed. So, you know, this is if you don't think this is important, this is what the jury's saying. Think about it. No, the Rittenhouse case hasn't come back yet. We're still waiting.
So they're missing a person, huh?
Thank you, Joseph. Thank you. I appreciate it.
Well, this guy's got these cameras and he lives in Douglas or somewhere. And he's always calling me, texting me video of the guy plundering through the house. Well, tonight the neighbor come by and saw the flashlight, somebody in here. So.
You use Mr. English's word, plundering, kind of like you're back in your grandma's kitchen. Mm-hmm. Plundering means messing around with stuff you shouldn't be messing around with.
The way I feel, yes.
Just like your grandma used to say, get out of our way. You're getting into my stuff.
Yes.
And that's how you use it. You got that word from Larry English, same word he uses.
Yeah.
So I just want to stop it here just from one thing. Remember when Larry English said that he wasn't a problem, that it was just, a couple of times? You've just heard on the body camera footage, if you could hear it, the officer said this guy calls all the time. This guy's always looking for this guy. This guy's always calling because this guy, this guy's very concerned. So that's what you're getting from the police body cam. So Larry English saying that this was not a problem, that's not what the police officers say. That's not what the neighbors say, right? All of this is here. You're watching it literally on video. And just so we're clear what we're watching the McMichaels who are armed. We're watching the police who are armed, right, with guns out, searching, and some other neighbors who are armed, searching for Ahmaud Arbery. And the police have already said, yes, we knew they were armed and we were looking for Ahmaud Arbery. But again, just the caveat, at this time, they didn't know it was Ahmaud Arbery, but now we know at that time that's who they were looking for. So this is what we're watching right now. And this is the prosecution's witness.
Oh yeah, man, that's good quality stuff too. He sends me the video of it.
Some good quality stuff. What are you referring to?
The officer, I believe it was Officer Sherman, was standing there looking up at the camera located on the front of the house. My body camera doesn't show it, but he's standing there with his light looking at the camera that Mr. English has mounted on the front corner.
So the good quality stuff is the good quality surveillance system that allows you now to know what this guy looks like and to be able to identify him.
Yes, sir. A lot of places we go to, the cameras look like they were from the 1950s, very, very poor quality. And those were some of the better quality cameras I have seen.
They did have backup there. They did have backup. He said the more the merrier. The more the merrier.
Now you're back out front, right?
Yes, sir. Walking back up to our cars.
We don't see him back there unless he jumped the fence this way or
Travis just walked down there. He's going in our backyard to check back this way.
Okay.
He's armed, by the way.
Okay.
Stop right there. So at this point, Greg McMichael is talking to you, correct? And Greg McMichael is telling you that Travis just walked down there. He's going in my backyard to check back this way.
Yep.
So Mr. McMichael, Travis McMichael at this point is kind of expanding the search.
Going down, I took that as he's going down to his residence.
In the backyard, or I'm sorry, yeah, he's going in my backyard to go check back this way, right?
Yes.
Because it's possible that the black male intruder is left that scene and is in somebody else's backyard.
Possibility.
And Travis is checking that out.
Yes.
And Travis is checking it out on February 11th, 2020 with a gun.
I don't know that he is checking out other people's backyards.
No, his backyard.
He's going to check out his backyard, yes.
And he's armed.
Yes, he is.
Just like he was armed when he was back at Larry English's house.
Yes.
He didn't go home, get the gun, come back out and go into his backyard, right?
Not that I'm aware of.
You're okay with that?
Yep.
No problem. He's right to carry a firearm.
He does.
And just like you're needing it for protection, he has the right to protect himself as well.
He does. On his property, yes.
On any property, he has the right to protect himself.
Yes.
I think all our guys are walking.
Red shorts and white shirt.
I wonder if it's the same guy, if he's got the sleeve. So Travis actually saw.
Not in this case. In this case, the police are the ones who said that he was armed, not the McMichaels. If you watch earlier, the cops admitted.
You have a camera in your window, right?
We didn't identify, I don't think, this guy. This is Ronnie Olson.
Ronnie Olson.
And he lives right across the street.
Yes, sir. Directly across the street.
Directly across the street, 219 Satilla.
I believe so, yes.
Did you understand that he had a surveillance system?
I knew he had a camera in his window, and he mentioned then he had one on the corner, the eve of his house.
But it just wasn't very good at night.
No.
But at night, it don't move through the glass. I don't have any vision out here after dark. I mean, on the eve and lazy. The rest of them on the eve. So it's not
Well, get with it, man. Get with it, man. Chop, chop.
He said he was lazy, so.
Yeah. Yeah, I'm gonna call Mr. English and get him to look back at his cameras.
Yeah, because he's got.
Nah, this guy, he's always on foot. Nobody in the neighborhood knows who he is. We can't identify. I've been about every house, door to door, trying to.
I know you said earlier, it wasn't really every house door to door, but 10 to 20 people, no one's seen them walking the neighborhood, running the neighborhood, jogging the neighborhood, doing anything in the neighborhood. No one's seen them.
No one had ever seen him.
ID. He's been on their video. They had video over here. We caught him on this guy right there. We caught him on several video cameras, but we just can't find where he's. And he usually goes this way, straight down that road.
Again, when you're saying he goes this way, you're talking about Jones?
Jones, yes.
Okay. I could just. Just to orient everybody, if they can see, and if you can see, Satilla Drive, here's the entrance up here. Can you see?
All right, I'm going to go back to the live trial testimony because they finished with all the pictures, it looks like. But if there's a trigger warning here, something may pop up that's crazy. If it does, I'll try to take it off the screen because YouTube is killing me with that. But we're going to go back to live trial testimony. But I just wanted, I just want to ask you guys how you feel. So we have 2 weeks before, right? The police are searching for Ahmaud Arbery. They've got him on camera. They've gone into the house. Dispatch comes over and says, hey, he may be armed. They tell everybody, yo, this guy may be armed. The Michaels are there. They're armed. Some other neighbors are there. They're armed. They go into the house, armed, guns out, searching for Ahmaud Arbery. Then the officer who was trying to say Arbery wasn't a problem before, that's what this officer kind of testified to before, now is saying that, yeah, he's been caught on all these cameras. We've been looking for him. I've been door to door. That's what he said. But even though he says he really didn't say that, but that's what he said. I've been looking door to door. We can't find him. They asked him, was he scared? Heart pounding, right? Because you got to take your gun out and you're nervous. So that's where we're at. That's the state of mind that the McMichaels are saying that they were in 10 days later. Because now, 10 days later, they got someone saying, hey, that's the guy just ran out the house. That guy that we were looking for 10 days ago. That guy that, everybody was armed looking for. That guy, that we believe stole something out that house. That guy who's been terrorizing the neighborhood. That's the testimony of this officer. I think very damning. And I think, it's putting those nuggets going into the jury. So let's get back to live trial testimony instead of this, so we can see what's going on, because they've finally gotten past all the gory pictures, hopefully. And we can now just watch live trial coverage peacefully.
Sternum, the breastbone. They've got the anterior fifth right rib, the fifth right intercostal space. That's the space between the fifth and sixth ribs. It got the anterior sixth right rib. It got the right middle lobe of the lung, the right lower lobe of the lung.
Yes, they never saw them take anything.
6 through 10.
They don't know if he took anything.
And the
That's a false statement.
corresponding
But I don't remember
6
this.
through 9th intercostal spaces.
If Travis did tell him, but the police were armed.
Did it break ribs 5 through 10?
I'll look at that again now, because I like to be right.
All the ribs
So
over here
I'll
got
check
broken,
it.
5 through 10.
Yeah. Yes.
What happens when you break all of these ribs over on the right lateral side?
Well, it becomes difficult and painful to breathe.
Just so we know
also,
where we're at. This is the medical examiner explaining the cause of death for Arbery.
Those ribs, so you would bleed into the chest cavity.
All right, so when we see Mr. Arbery with all the blood underneath him at the crime scene, was that due to that blood into the
I would just ask,
cavity?
is it reasonable for a person to believe that Arbery was armed
So
later,
the gunshot
after being
wound
kind of
to
told that
this
he was
torso,
armed before,
was that
or he may have
a
been
fatal
armed before?
gunshot wound? If he had never gotten this one under the arm, would
That's
that
what you're
one in the
talking
middle
about.
of his
Reasonable
torso
person, not if it actually was he was armed.
Was there anything
What a reasonable
EMS
person could they come to the conclusion
the
that
officers could have done on the scene to save his life from the torso shot?
Well, they could put an occlusive dressing on the large defect, but you would still have the exit defects in the back of the chest. And they couldn't do anything about the bleeding as long as the heart was beating.
So would he have just, in other words, is there anything they could have done on scene to save his life?
No.
And then I think lastly, we have State's Exhibit 413. So I'm going to show you what's been marked as State's Exhibit 413. I'm just going to show you the.
She's asking, is there anything
exterior
they
of
could
the
have done to
bag.
save his life
Prior
at
to
the
coming
scene?
in here
And no,
today,
there's nothing they
were
could
you
have
able
done.
to
He had just
examine
had two
all
shotgun
of the
holes
items
pumped through him,
collected
so
from Mr. Arbery, including
he was
his
not
clothing
he was
and
not
the
going to be
shoes?
alive.
Yes, I was.
All right, and is what's contained in State's 413 the shoes that you collected from Mr. Arbery?
Yes.
At this time, the state would tender into evidence, State 413.
No objection.
So this is a point of contention because people keep saying that he had Timberland. So now we're going to see the
Object
shoes.
on relevance grounds. What's the relevance of these tennis shoes?
So he didn't have Timbs on. He had or construction boots, as a lot of people are trying to say. He had tennis shoes or sneakers.
Objection, Your Honor, if this is going to be a speaking response to this objection, we would ask that it be done outside the presence of the jury. It's an issue the court's been very clear about.
Okay, ladies and gentlemen, if you could just step into the jury room for just a moment.
All right, for the jury.
All right. So just let me let you know. All right. So the people are trying to introduce that his tennis shoes, right? Tennis shoes or sneakers, right? Now, obviously, what's the implication of tennis shoes or sneakers, as we call them up here in the North? Well, if he's wearing running shoes or tennis shoes, then he's a jogger, right? It's more likely he was a jogger. He was just a jogger. Look, he's wearing jogging clothes. But if he's wearing construction boots, he's less likely to be a jogger. So the implication of this is that he's a jogger. And that's kind of what they're trying to get against. Like, why are you even bringing in what type of shoes he wore, right? What's the relevance of him wearing tennis shoes? Was he a jogger? Why are you trying to admit this in? So that's what I believe they're
The
going with
state
this.
does not wish to put in a large amount of his clothing due to the contamination situation. So we're not going to put in the belt and the pants and the t-shirt or anything like that. They have photos of those items. The shoes in the state's opinion are relevant because the state's argument is going to be simple, that Mr. Arbery, based on the evidence, when he would visit 220 Satilla Drive for a few moments and go in, would take off running into the neighborhood. That's the evidence. So this, of course, shows that that particular day he had running shoes on. This is what he was wearing. He walked up to the residence and then he ran away. And these are just the shoes that he was wearing.
Am I good or what? You could easily call that argument, right? And it's like you knew exactly where she was going. She's trying to, and just so everybody understands what's happening, she's trying to backdoor in the jogger thing, right? She's trying to kind of backdoor it because she's like, there's no evidence that he was really a jogger, so you really can't say it. Now she's trying to get it into the back door with the sneakers, right? He was wearing sneakers because she even virtually said jog. She's like, because after he goes to the house, he goes out running, right? We don't want to get the rest of his clothes in, but we want to make sure we get those sneakers in. It's a nice, it's a nice tactic, but let's see if the judge goes with it and lets
So it's evidence of what he had on that particular day, his running shoes.
It's a backdoor way of entering into evidence what the court has already ruled so far the state can't do, which is to argue that Mr. Arbery is a jogger in the neighborhood. There is no relevant.
I'm sitting anyway with my thing muted. But am I good or what? He just literally said what I just stopped the video and told you, right? He just literally said exactly what I just said, right? Word for word, right? She's trying to backdoor in a jogging thing, right? She just literally said that. So again, we all know what she's trying to do. But will the judge let it in? Will the judge let these sneakers in? Because we know what the sneakers are, right? We know what the sneakers are for. Let's see.
Of the shoes in and of themselves, it didn't inform this doctor of anything he had to do in performing his autopsy. If the state wants to argue that Mr. Arbery is a jogger based on the fact that he's wearing tennis shoes, then we should have the right to provide, again, that alternative explanation for why he's running.
I join in with Mr. Rubin's objection for all of those reasons and reiterate now for the third time, the shoes and their condition and the type of shoes they are is just another way of saying to the jury, look how much he runs. He runs all the time. Therefore, that's what he was doing on 2/23/20 when they encountered him in Satilla Shores. If that's the relevance of the shoes, the state hasn't said it quite that way, but that's the only relevance of them it could be. It opens the door to us to say, well, then let's give you some alternative views for why he would be running in Satilla Shores on 2.
So I put a poll in the chat. Would you let the shoes in? Would you let the shoes in? Poll in the chat.
2/23/20, what we had an argument about the other day and the court made a ruling. This isn't the same type of evidence the state's trying to introduce now.
Based on the state's explanation of why they're tendering this exhibit, we will join in the objection of the McMichael defendants. I'm very concerned about these shoes going out to the jury. My understanding these are in fact Max Air Nikes. Most but not all of these brand of running shoes, these athletic shoes, are running shoes. Some of those branded shoes are shoes for other events, such as basketball. Now we're going to be sending back these shoes without any expert testimony or other testimony establishing what kind of shoe they are for the uninformed and unguided speculation of the jury as to whether these are in fact running shoes or not. There's been no testimony, and unless there's something in the discovery I didn't see, there's been nothing presented as to the tread or the composition of these shoes to establish if they're running shoes. We're just going to send them back to the jury and ask them to speculate about it. That's highly improper. And I agree with the McMichael. It's going to open the door to all kinds of testimony that I thought the state didn't want to get into. I object at this point to tender of these shoes.
I won't tender the shoes. That's fine.
I understand. Tender's withdrawn. Tender's withdrawn then?
Yeah, I'll withdraw it. That's fine, Your Honor.
Sweet now.
So she's pulled back the shoes. She knew she was going to lose that one.
Photograph of the shoes that was used in the opening statement, and apparently has been introduced somewhere along the way here, hasn't already done the same thing the actual shoes have done. so that the state will now think, well, we can go ahead and argue in closing argument by showing the photo
She
of the
pulled
shoes,
out the
what
shoes
they
and
argued
ate
in
the
an
shoes.
opening statement, and that is he's an avid jogger. Again, we don't dispute that he was an avid jogger. We just dispute whether we can now offer an alternative explanation for his running.
Whoever
on a
said no is
particular day
right.
and place.
Congratulations.
So if withdrawing them now still leaves the state open to making that argument in closing. If they're indicating that's what they plan to do, then the door's open. And we should be allowed to give alternate explanations for his running on 22320.
As I understand it, the state has withdrawn the tender of these shoes, so that's not an issue. As far as opening the door, whatever evidence is in, and as far as the court is concerned, that door has not been opened. So let's go ahead and get the penalty.
Yeah, I mean, just to clarify then, if we don't know whether that's the argument in closing until they get to the closing, and the evidence has been closed, then we've lost our opportunity to provide an alternate explanation for what I anticipate will be an argument by the state to the jury.
No, the door has not been opened. If that's an argument that's made simply based on a pair of shoes that Mr. Arbery was wearing, that's what he was wearing at the time in the neighborhood. But there's other evidence that can be argued. So no, it has not opened the door to matters that have not come into this point.
May I inquire though, Your Honor, because I'm really trying to follow with you and perfect the record, not arguing with the court. The shoes, though, are of particular evidentiary concern to the state and obviously, therefore, to the defense. His belt is of no concern. His shorts are of no concern. The shirt's value is minimal. It just shows where he was shot. His underwear is of no concern. The shoes, though, are critical, as I see it, to the state's argument that they've set up from opening statement forward. So I'm not sure what the court's saying. Other evidence that has been introduced has to do with the evidentiary value of the shoes. And of course, the shoes themselves now are being withdrawn, but the photos in, the argument's been laid. I think the door's been opened already. That's our position, Your Honor.
I don't know what the court has specifically said. Based on what I understand of the evidence at this point, the door has not been opened.
A related point, Your Honor. Under Georgia law, the state has the opportunity to open and close. In this part of the state, prosecutors typically waive the opening portion. I think Ms. Dunn-Cassidy has indicated that she's not going to waive the opening portion. My concern is the court has discretion over closing arguments, and I would ask the court to require the state, if they're going to address this running shoe argument in their closing, that they do it in the first half or first portion of their closing, so that defense counsel can hear the state's argument for the first time before we have to respond. Otherwise, the state's going to come in after everybody's rested and throw this argument out there, and we're not going to have any options other than to try and object to it. And it's a notice issue, not just a fairness issue, not just whether it's based on the evidence. It's a due process fairness issue for the state to come in after all the defendants already rested in the trial and put forth some novel argument, some clever argument based on photographs with respect to these running shoes. The court has the discretion to require that argument that's going to be made prior to defense counsel having to give their closing statements, unless the court's planning to allow us to reopen and re-argue the case after the state is done.
Why don't we reach this at some point that's more relevant to where we are in the trial? I'd like to get the jury back in to finish this witness's testimony. The state has withdrawn its tender. If you want to raise that matter later, you're welcome to do so, and we can address that. Let's go get the panel.
All of this is to backdoor in the fact that he was a jogger. This was good, though. It was a good shot. I think that she should have just tried to bring in all the clothes, right? She should have just said, hey, I want to tender the belt, the shirt, everything, right? Because you get the shoes in with all that. But the problem is that you get the other side gets to argue, well, hold on, here's the evidence he wasn't a jogger. So the prosecution wants to get the evidence that he was a jogger in, but doesn't want them to rebut. So she was trying to sneak it in kind of underhanded, like, all right, let's throw these sneakers in with this. And it's like, all right, no. So we'll see. We're going to see. But so she saw where that was going. She saw that, hold on, if I get these shoes in, they're going to be sitting there screaming, well, he wasn't jogging, right? And all these, so we're going to say, no, he's not a jogger. So she said, I'm just pulling the shoes out. But the damage has already been done a little bit, right? Because she was in front of the jury saying, we're going to put these sneakers in the evidence. And now when she's going to come back and say they're not. So the jury already knows he's wearing sneakers. So she already got the evidence in front of the jury. She's already got the sneakers in front of the jury. Nice little tactic.
Welcome back, ladies and gentlemen. I understand the state is withdrawing the tender.
Yes, sir. Dr. Donahue, what was Ahmaud Arbery's cause of death?
It's my opinion that Ahmaud Arbery died of multiple shotgun wounds.
I'll pass witness.
Morning, doctor.
Good morning.
So people don't understand how smart it
Donahue,
was.
my name is
She
Bob
got
Rubin.
the
We
sneakers
spoke on
in,
the phone
but
way
she didn't
back
get
in
them in on
March
the
of
record.
2021.
And they
I
can't
don't know if you
respond to the
recall.
sneakers. That's what they're afraid of.
And then I think we spoke just about a month ago in October, shortly before trial began. Do you recall that as well?
I don't recall that.
You remember being on a phone call with Ms. Hogue in
Yeah,
October?
yes, I do.
You may not have known, but I was on that call too.
Okay, all right.
Thank you for being here today. I want to ask you a couple questions just about your background. You were the medical examiner and then chief medical examiner in Cook County, Illinois.
That's correct.
And during that time, is it fair to say, Dr. Donahue, that you saw dozens, maybe hundreds of cases?
Good point. Good
maybe more
point.
than
She's
that,
playing
of
chess.
gunshot wounds?
Yes, that would be fair.
And of those gunshot wounds, the subcategory of shotgun wounds, would it be fair to say you saw at least dozens of those?
Well, the shotgun wounds were less frequent.
So less than the gunshot wounds total, but still a substantial number?
Yes.
And over the years, it's your, and even in your time with the GBI, it's your practice to, in examining a body before autopsy, is to start kind of from the outward and work your way in.
That's correct.
Okay. In this case, going back to February 24th, 2020, Mr. Arbery was brought into your autopsy room, correct?
Yes.
Photographs of the outside of his body were taken by staff.
Yes.
And you have a death investigator working for you.
Yes.
And her name is Shannon Walden.
Yes.
Okay. Does Ms. Walden still work with you?
Yes.
Okay. And you have other staff as well that help you with the autopsy process.
That is correct.
When Mr. Arbery came in, did you have some information about what happened in Satilla Shores on February 23rd?
Yes, I did.
Okay. And
let me stop with the jogger narrative. I think this is a very good question. That's why I'm stopping the video. Let me change the scene. All right. So this is, do you think the innocent jogger narrative is so far removed from reality? Yes. The reason what, so everyone understands what's going on. Arbery, the innocent jogger Arbery narrative, there's no evidence that he was a jogger, right? So the state is afraid because if they put on evidence that they believe he was a jogger, that allows the defense to put on evidence that he wasn't a jogger. So the state wants him to be the innocent jogger, but they understand that that opens them up to that counter evidence. So they do not want to have that go in, right? They do not want that to go in. And that's the issue that you have now. That's the issue that you have with this evidence, this testimony. So, you know, it just is what it is. Unfortunately, they don't want this testimony, this evidence to go in because that opens them up to that collateral issue. So that's why you see this fight over the sneakers, even the sneakers, any mention of it, because the judges already said it's not an issue here, but if you make it an issue, then you can get caught with it. So the state is trying everything they can just to sneak it in, but they don't want to put it in on the record.
Tell us who provided you the information?
Well, Alexis Brown, who is a death investigation specialist, was contacted by Deputy Coroner Christy Rozier of Glynn County.
So Ms. Rozier from Glynn County Coroner's Office gave information to Ms. Brown, who works for you.
That is correct.
And passed that on to you.
We wrote a report, yes.
Ms. Brown wrote a report.
Yes.
Okay. And at that time, were you aware that there was a video of the shooting in Satilla Shores?
I was not.
Okay. When was the first time you were made aware of that video?
I don't recall. It was certainly after I wrote the report.
It was after you wrote the report. Of course, the video itself became public in April of 2020.
Well, that's probably when I heard about it, yes.
When it hit the news, did you connect it to Mr. Arbery's case?
Well, I would have connected it to Mr. Arbery's case, yes.
Okay. So that was May or June, would that be fair to say, of 2020?
Well, I'll have to go with you because I have no recollection exactly when it was.
Okay. Did Ms. Brown, Ms. Walden, or you say at that point, oh my gosh, we have a video of the shooting, let's go back because we could amend our report?
No, I don't think anybody said that.
Okay. Was there anything preventing you from obtaining a copy of the video from Glenn County Police or the GBI so that you could look at the video and compare it to your report to see if you did want to be more accurate in your analysis of the case?
Well, there was nothing preventing us from doing it, but I don't think we saw any reason to do it.
No reason, I guess, because your report was your report.
Well, I don't understand that question.
Well, you changed your opinion on a couple matters after viewing the video.
Yes.
So when you say there was no reason to look at it in May, June, July, August, September, etc., I'm not sure I understand your answer.
Well, I can tell you when I first saw the video, it wasn't broken down into individual frames, and it was really difficult to tell exactly what was going on. It was so fast.
Okay. Did you ever contact the GBI and say, hey guys, when you slow this down, or when you do break it down or get it enhanced, call me up because I'd love to look at that?
No, I never said that.
So on February 24th, you did your autopsy and you examined the shirt as we saw in the photographs. And then the shirt was sent to the crime lab, was it not?
Yes.
To be examined by crime scene analysts, not crime scene analysts, by GBI crime lab technicians like Brian Leopard.
Well, yes.
You knew at the time you did the autopsy that Mr. Arbery was wearing the shirt, right?
Yes.
And you knew that since you were examining shotgun shots, that shirt came between the muzzle of the gun and his skin.
Yes.
Okay. Did you then at that point request Mr. Leopard to examine the shirt to see what he found in the shirt?
I did not.
Wouldn't that be standard procedure when there's an article of clothing between a shotgun or a gunshot and the skin of the individual?
No, it is not standard procedure.
Did you later learn that Mr. Leopard, in fact, did an examination of the shirt and came to a different conclusion than you did in terms of muzzle to target distance?
I did.
Okay. When did you first become aware of Mr. Leopard's conclusion that it was a contact or near contact wound?
I believe on September 23rd this year.
Of 2021?
Yes.
So if he testified yesterday that he came to his conclusion, I think in June of 2021?
Yes.
He didn't call you.
That's correct.
The GBI didn't call you.
That's correct.
This Cobb County District Attorney's Office didn't call you.
That is also correct.
To see if it would make any difference. It was Laura Hogue who contacted you to see if Mr. Leopard's conclusions would impact your analysis.
Well, no, I found this out on the 23rd. Laura Hogue contacted me on the 29th.
Of September?
Of September, yes.
Okay. Prior to, well, you found out from who?
Well, we had a pretrial meeting with the prosecutor and Brian Leopard was there.
Okay, so that's the first time, September of this year, a couple months ago, is the first time you understood.
That's correct.
Okay. For everybody's concern, I'm not going to touch the shotgun in evidence, but I have a very poor simulation, just a piece of tubing.
Okay.
Your initial analysis of target to muzzle distance was 3 to 4 feet,
That's correct.
based on the wounds that you saw.
That's correct.
And 3 to 4 feet would be approximately this distance.
From where to where?
Well, I'm sorry, from here to the front of the bench. That look about right?
Looks a little long. Yeah, probably about that.
Does that look about right?
Yes.
That's a big difference in analyzing a case from inches.
Yes.
They're not using a gun, right? They're using a stick. You probably saw how Binger took a L yesterday on the whole pointing a gun at someone.
When you examined Mr. Arbery, I think you testified that he was 5'10", 164 pounds, muscular.
Yes.
And you again, you may not have testified it, but you found in your examination he had tattoos along both arms. Is that correct?
Yes.
Did you analyze that tattoos at all and provide that information to law enforcement?
I did not. We photographed the tattoos.
And provided your photographs to law enforcement?
Yes.
Okay. He was wearing tan cargo shorts.
Yes.
He had on a camouflage bandana, right?
Around his neck, yes.
And a tan bandana.
Yes.
Also around his neck or somewhere else?
Around his neck.
So 2 bandanas. In examining his body, did you note that his toenails were very long and dirty?
I did.
Toenails very long and dirty.
You've testified to the 3 wounds that you found. Center chest, left upper shoulder, armpit area.
Yes.
And I know these are not the technical terms that you...
No, those are fine.
And then the right wrist going from thumb to pinky graze along the right hand.
Yes.
Am I saying that right? I think you used the term radial to ulnar.
Radial to ulnar or thumb to little finger.
Thumb to little finger. And would it be accurate to say that the path was along that way, or are you saying it was
No, the path was it was kind of triangular, and it was the axis would be perpendicular to the long axis of the arm.
Could you show that again for the jury?
Well, we have a picture of it. I think that would be the best way to show it.
You want me to go through 1,095 pictures?
And I don't. Maybe I could do it.
Well, let me see if I can easily access the photo.
Dirty toenails. I don't understand what the dirty toenails thing is about either.
Okay, that's the picture.
So is it going like that?
Well, I think the picture speaks for itself.
Well, I'm asking you if you could help us here.
Use a pen to show what he would.
No problem with that at all. Dr. Donahue, can you step down and maybe help us?
Step down.
You step down. The document's right there on the document camera.
Okay.
Let me get this door for you.
Thank you.
State's Exhibit 12.
Yeah, but
Exhibit 12 shows the wrist and the thumb.
Do me a favor and just put your pen so we can see it on the board.
Okay, there it is.
Okay.
And that is going from the thumb side to the little finger side.
Okay. And I guess my question is that like straight across?
It's
or is it at an angle?
It looks like it's a triangular movement. It's expanding as it goes farther.
Okay. And so what does that tell you about that movement?
Well, it tells you that it probably started on this side and was shot this first.
Okay. Okay. Thank you. You knew at the time of your report in April that the gunshot wounds on Mr. Arbery's body were the result of a struggle over a shotgun.
Yes.
Okay, and you knew that from the information gathered by, I think you said Alexis Brown.
Let me just check on that.
Didn't know. But that's one of those weird questions that you got to explain to the jury, though. Why do the toenails matter? Long, dirty toenails. Interesting question for the day. But thanks for the explanation.
Well, it says an altercation
but that makes sense
resulted
too.
in him being shot multiple times.
Well, it says a struggle over the shotgun in your report, does it not?
In my report.
On page page 5 of your report, didn't you state that the 25-year-old black male Ahmaud Arbery died of multiple shotgun wounds sustained during a struggle for a shotgun?
Yes.
Okay. So you were aware at the time you wrote the report that there was a struggle over a gun?
Yes.
You were aware, were you not, that Mr. Arbery in fact had his hand on the shotgun?
Well, if there was a struggle, I guess he did. I didn't have any video of the incident.
Okay. And the video wouldn't change that. You saw, in fact, in the video and in the frame by frame, a struggle over the gun.
Right.
You saw in the frame by frame that Mr. Arbery had his hand on the shotgun, correct?
Yes.
You saw in the video and in the frame by frame that even with the wound to the wrist, Mr. Arbery was able to swing punches and hit Travis McMichael.
Yes.
Nothing about the radial artery or the wound that we saw in Exhibit 12.
Ulnar artery.
What did I say? Radial artery, not radial artery, ulnar artery.
Yes.
Okay. Nothing about that wound, the blood spurting, or any other damage to the tissue prevented Mr. Arbery from holding the gun.
Oh yeah, you're going to see a lot of those
and swinging
sneaky.
and
Let's just try to get some runner, non-runner evidence in there. Let's put the shoes in. Oh no, these weird sneakers. No, all right.
Of course,
put
as a
them in.
medical examiner, it's
He's
not
got long
your
toenails.
concern of
What does it
led
mean?
up to
Who
that
knows?
moment.
Bringing the toenail expert.
You don't know what happened at Larry English's house?
No.
You don't care what happened at Larry English's house?
Well, I don't know that I don't care.
Because you don't know what you don't know.
Yeah.
Okay. You didn't ask about what happened at Larry English's house. No one reported it to you.
Well, there was television coverage of that.
I mean, officially.
Oh, no, officially, no.
Okay. It wouldn't change your opinions in this case. You're looking at the body and reporting as a scientist what you see on the body.
That's correct.
Okay.
Yeah, I think we may be overthinking it, but you don't ask questions for nothing, though. What's the reason why he asked that question?
Why you came to the
Would you ask about somebody's dirty toenails?
That the chest wound that you examined,
long dirty toenails, at that, right?
That the target to muzzle distance of the chest wound, in your opinion, is from 20 to 3 inches, and Mr. Leopard's opinion is it's either a contact or near contact, which he describes as an inch. Did you ever reconcile that?
Well, I told him that I thought that he was shot through the wrist in front of the chest. And no, I guess we never reconciled that. Although, I felt because we kind of agreed because we both said it could be a close contact wound.
So the one area of agreement that you have in your muzzle to target distance is you both agree it's at some point it could be within an inch to 3.
It's possible, yes.
Okay.
I said 3 inches. Yeah.
You said 3,
yeah,
but he testified to 1, and you disagree with that opinion.
Well, I don't disagree with it, but my opinion is 3
okay.
Because you have the wrist there. You can't get any closer.
So let's talk about that for a second.
So he is disagreeing with them. What? He's fighting with him a little bit.
You were asked.
Like, I don't disagree, but it can't be less than 3 because his wrist was there.
If you could determine the sequence of shots.
Yes.
And through Shannon Walden, you reported to Lawrence Kelly, that's his right name, Agent Kelly, that you could not determined sequence of shots, right?
That's correct.
Okay. You were asked actually by the FBI in July of 2020 if you had an opinion about the sequence of shots, right?
Yes.
And you reported to the FBI that no, you don't have an opinion as to sequence of shots, right?
Yes.
Okay. Now, by July of 2020, certainly you were aware there was a video.
Yes.
Did you say to the FBI, you guys, if you want an opinion, bring me the video and I'll look at it?
Well, that's not how it runs. Usually there's a prosecutor who will contact us and we'll talk about the case. And at that time it might come up, but we don't continue to work on these cases if there's nothing happening.
Okay, but you were being contacted now by 2 investigative agencies and asked your opinion. You were aware they wanted your opinion about this.
Well, I'm not sure why they wanted my opinion about it. In fact, the people should know generally we do not have opinions about the order of the shots.
It actually is something that's fraught with danger for a medical examiner to give an opinion about the order of shots.
The medical examiner just can't do that. I don't know how he could do it.
Right.
This is an exceptional circumstance where there's a video.
Right. And that's what you told the FBI. We don't do that. That's not something our office does.
Correct.
But once you were provided the video, you now, as you've testified, do have an opinion about the order of shots.
Yes.
Okay. And it's based on your analysis of the frame-by-frame photographs from the video.
That is correct.
Okay. Ms. Dunikoski posed to you a couple hypotheticals of how Mr. Arbery's wounds were in fact inflicted, right? One question was, could the wound to the wrist, which you've described now for the jury and shown them, have occurred because Mr. Arbery swiped the gun and somehow the shot was from his thumb to his pinky?
Well, that's not exactly what she asked me. I don't, and I think I answered that question with a no, didn't I?
I think you did.
Okay.
Okay. Another alternative explanation, would you agree, is that Mr. Arbery in fact grabbed the gun, and when the gun was pulled back and fired, it could have caused the injury.
That could have happened, yes.
And that is consistent with
the injury is to the wrist, though.
Would have been more like that.
Yes.
Okay. And that's consistent with the video and the frame-by-frame analysis that you've seen in this case.
Well, I don't know. I couldn't see where that happened. It happened in front of the truck. So,
right. So you're doing your best to give opinions, but you really couldn't see.
Well, I know the location of the wound, and I know that it bled.
So when you do see the wound to the wrist, it's already to the left of the truck as we're facing.
Well, I don't know that all I see is the blood coming from the wound at the wrist.
Right. And I mean, that's what informed you was the blood.
Right.
The arterial spurt.
Yes.
Okay. My question is it consistent with the wrist wound for Mr. Arbery to have grabbed the gun and the gun been pulled back by Mr. McMichael when it was fired?
That's possible.
That would have explained both the injury to the wrist and the injury, the close contact or near contact or 3-inch wound or distance.
Allow room for the wrist, and we're
right.
agreed.
Couple inches. Okay.
Just so everybody knows where we're at, what he's trying to do is make the argument that Travis didn't shoot. In other words, Travis didn't pull the trigger. He's saying when Arbery grabbed the gun, Arbery pulled the gun, causing the gun to fire. That's what he's trying to allude to with this guy. That the reason why the hand is important, and I don't know if you saw how he kind of led us down that path. The reason why the injury to the hand is important because he's saying he pulled the gun that caused the shot, and it wasn't Travis shooting him actually. So he's trying to get that out of that. Hey, Travis didn't shoot him; he actually pulled the gun, causing it to go off. So he's actually blaming the kill shot on Arbery instead of Travis McMichaels. If you buy it, that's it. But that's the argument he's making.
Was all the jury able to see that?
You testified today. By the way, I don't know, from looking at the video in your analysis for this case, did you determine how many times Mr. Arbery punched Mr. McMichael?
I did not.
You didn't count it?
I did not.
Okay. In testifying about Mr. Arbery's actions after being shot, let me back up a second. You watched the video and saw him, despite having a shotgun wound to the chest, which was fatal.
The chest and the wrist, yeah.
And the wrist. He's still able to push Mr. McMichael through the truck off screen from the video.
Yes.
Some 10 feet or more from what you can see on the video.
Yes.
Still able to punch and grab the gun at the same time he's punching from the video.
Yes.
And you described the adrenaline that Mr. Arbery could have had, which could explain why he's able to continue doing that.
Yes.
And I think you described it as a fight or flight response.
That is correct.
Now, again, you don't know what preceded what you saw on the video, right? In terms of what Mr. Arbery had been doing beforehand.
Well, there's a lead into the video. He was obviously running.
He was running towards Mr. McMichael.
He was running toward the truck.
Well, did you see Mr. McMichael in the video?
Yes.
Okay. He's actually running towards Mr. McMichael, is he not?
Well, I don't know that he was running toward Mr. McMichael. He went around the right side of the truck.
Went around the right side of the truck and then cut left.
Yes, he did.
Okay. And did you see to the right of Mr. Arbery a yard, a neighborhood?
Yes.
Okay. So you're not saying in looking at the video that he couldn't have continued to run, right?
Objection, speculation, and by the way, I think the jury can go ahead and see and determine what Mr. Arbery could not have done.
I think Dr. Donohue's testimony was in describing fight or flight that after he could no longer flee, he could fight. And I'm asking him, is there any evidence that Mr. Arbery could no longer flee?
So you're asking what that's based upon?
What his testimony was based upon.
Good.
Okay.
What, could you repeat the question?
Sure. I believe you testified on direct examination that someone in the fight or flight mode, when they can no longer flee, can fight.
They can.
Okay.
Yes.
You didn't see any evidence that Mr. Arbery could no longer flee, right?
Well, no, I didn't.
Okay. You examined his body. He was a muscular 25-year-old man, right?
Yes.
Looked to be in good shape from the autopsy, physical shape.
Yes.
Okay. And so there was nothing physically preventing him from continuing to run, right?
No.
And nothing, in fact, from the video you examined from the neighborhood preventing him from running.
That's correct.
You described the basis for the adrenaline dump and cortisol running through his veins as caused by stress.
Or fear.
Or fear.
Yes.
Anger.
Anger too, yes.
Okay. And you have no idea what he was afraid of at that point in time, correct?
Well, there's a man holding a shotgun out there.
Right. So could have been afraid of being shot.
And there was a man following him in a pickup truck.
Okay. Could have been afraid of being caught.
Caught? I don't understand.
Do you know if Mr. Arbery was afraid of being caught?
I don't.
Right. You don't know what you don't know.
Well, yes, I don't know what I don't know.
I think that was a bad exchange for the defense, because you got him saying he was being chased by another truck, like that all comes in. So the jury's hearing all that. Those are bad. It was a bad exchange. You got to get him back on point.
You testified that there was nothing that could be done on scene that could save Mr. Arbery's life. Is that correct?
I think that's correct. Yes.
the phrase you used when you talked to us in March is he was essentially dead before he hit the ground.
Yes.
Excuse me, 1 minute.
Like, what else do you get out this witness? It's like, here's the pictures, here's where he's shot, here's where he's hurt. I don't see what else you get out this witness. I don't know.
Any additional questions from the defendants?
Not from Mr. McMichael.
Yeah, I don't see what you, what else do you need?
Just a moment, Your Honor. Nothing further from the state. Of course, we reserve the right to recall the doctor.
Thank you, doctor. You can go ahead and step down. You are subject to recall.
Thank you, Your Honor.
Thank you. All right, ladies and gentlemen, it is
That's it. We're
noon.
going
Let's
to
go ahead
lunch.
and break for lunch. We'll break until 1 o'clock, and then we'll continue with the evidence at that time. Thank you.
All right, for the jury.
All right, so we got that done. I don't know. I thought that cross-examination, it went well. I thought the direct went well, but obviously the big high point is the shoes. They want to get the shoes in. One person's getting in shoes, the other one's talking about toenails. So we're trying to get the fact of the whole running situation. And one side wants to put in sneakers to show he's running, the other one to show long toenails to show that he wasn't a runner. So what does all this mean, right? So obviously that's a key point of contention in this trial. Just so everyone also understands about the running issue, the court has made it clear that whether he's a jogger or not was
from Travis Michael.
it was irrelevant.
Mr. Bryan. There you are. All right, we're in recess then until 1 o'clock. Thank you.
And you know what? This also lets you see how attorneys work in court, right? Because they're trying to get this stuff in really in an underhanded way. He had long toenails that were dirty. He was so anybody who's on that jury knows anything about running, right? Who's a runner who knows what that toenail thing is, got him with the toenail thing. The other one, hey, we're gonna put these sneakers in. Objection, objection. Okay, we're not gonna put the sneakers in. Why do we? Why the sneakers need to come in? Because he was a runner. So, they're trying to get it in without getting it in. And the reason why they have to do it in this manner is because the judge said it's irrelevant whether he's a jogger or not, right? We're talking about what happened at that time. So if he's a jogger every day, what does it matter? If he wasn't a jogger, what does it matter? But obviously it matters to people who want to know why, because the question is, I think everybody has to really understand, what's the question in this trial? Why the hell was he there, right? Why the hell was he there? That's what you kind of have to overcome in this trial, right? Why was he there? And for what reason? So, and I know one theory is he was a jogger. The other theory is that he was a prowler, which is more correct based on the facts. So, mom says he was a jogger. Yes. Jogger, seriously, but the thing is that if you get, because I'm assuming you're going to get people coming on the stand and saying, did you ever see this person? Because if somebody's a jogger, you're probably going to see them in a neighborhood, especially a neighborhood like this. And if nobody ever sees you jog, are you a jogger? Are you a runner? He's in good health, that type. Who knows? No one ever said he was a professional runner. A jogger is different. That's true. But again, I'm just saying the reality of the evidence that we have in front of us, right? The reality of the evidence that we have in front of us, because that's the key reason why this is important. I think a lot of people just don't understand why the jogger piece was important, because the jogger piece is important to give him some legitimate reason for being in that neighborhood at that time, doing the things that he was doing. And jogging does that, right? Jogging does that. Jogging, if you're a jogger, it takes you into places where you don't live. It takes you around, areas that you don't usually go around. So that's what the jogger narrative gets to. But the jogger, but again, understand the reality of the situation is that they're not allowed to call him a jogger because there's really no evidence of it, and that opens them up to that collateral attack where let's look at the evidence that no one is a jogger, that he was not a jogger. So it's been pretty interesting this morning. I personally don't know why the hell I wouldn't have gone after the old guy doing this. Like, for what reason? Like, the autopsy guy's like, all right, you give him a couple of questions. I think it was good to get the whole hand thing in there, though. The fact that he pulled the gun, and that could be a separate reason why he was shot. So I think that was a smart move, and I think that's what you get in. But then the whole wrestling with him about, well, he's running from him and he's doing this. I think he lost a little ground with that, but he should just kept it short and sweet. The gun, the him pulling the gun toward, him blaming Arbery for the shots. I think that was a nice little play. How can you say the action of the death was self-inflicted? I'm not saying he said it. I'm not saying that's exactly what he said, but he said it's a possibility. Again, that's all you need to throw. That's what defense attorney wants to do. They want to muddy it up. Hey, he might have didn't pull the trigger. He pulled the gun, and that's giving you an out, right? It's just giving the defense an out. You heard it from this guy. He said that it was because the gun was pulled, right? That's where you're going with this. If there's video evidence, but there's video evidence whether he pulled the trigger or not, right? That's what they're arguing about. Also, those shotgun wounds don't seem to be self-inflicted. Oh no, they're not saying it's self-inflicted. They're saying that when he grabbed the gun, Travis Michael was holding the gun, but by pulling the gun, he activated the trigger. Pulling the gun one way, trigger goes back. That's why I agree with you, Mr. Nobody. I think it's I don't believe it. I personally don't. I think it's bullshit. But he elicited that from the guy. Is it possible? If he said no, then I would be like, oh, but he said it's possible. So you got to deal with that. And again, it also explains why the injury is on his hand. Because remember, that's how he kind of got it in there. He was like, well, how did he get this hand injury? Could it be from him grabbing and pulling him? But if he does that, couldn't that also lead to this, the gunshot going off because he pulled the gun? And so he led you right down that path. Why do or don't you think that McMichaels have a self-defense aspect here? I do believe that there is an aspect here, but I think just like in the Rittenhouse case, in this case, the self-defense aspect of it has to do with the legitimacy of the citizen's arrest. If the McMichaels were conducting a legitimate citizen's arrest, a lawful citizen's arrest, then they have a right to self-defense. If they do not have a legitimate right to the citizen's arrest, then they do not have a self-defense argument, right? Because their argument here is that if the citizen's arrest is proper, then they're trying to effectuate an arrest, and then Mr. Arbery, the situation is different where they can now stop, and now you put all those things into play. Let me go down real quick. All right, so let's say that this is a legitimate citizen's arrest. For argument's sake, right? I'm not saying this is what the trial is showing, but I'm saying for argument's sake, let's say this is a legitimate citizen's arrest. If that's the case, then you can use force to effectuate that citizen's arrest, and you can use just as enough force to overcome any force being used against you to resist. So in that case, and this is for officers or regular people. So in this case, you then go to, okay, so why do you need guns, right? Because you got someone who's unarmed. Why would you need guns, right? That's too much force, right? You just got to be proportional. But here, the defense is going to go back to the video we just played earlier of, we thought he was armed, right? The police thought he was armed. Everybody thought he was armed. So that's the reason why, they had all us looking at him, looking for him, because we all thought he was armed. So that's going to go into their state of mind on whether they were armed. So then that covers the armed piece. And then because we thought he was committing burglaries and he was a burglary suspect, we were trying to effectuate that citizen's arrest. And in doing so, he then lunged at us, and that gave me the right to protect myself because he's lunging for the gun. And then you got the shot on the hand, shows you he was lunging for the gun. He tried to grab the gun. He was trying to avoid the citizen's arrest. So it essentially deputizes them and makes them like police officers, right? If you lunge for a police officer and they shoot you, you're not really going to have an argument. But now in reverse, let's say it's not a citizen's arrest, right? The citizen's arrest is no good. Well, that changed the whole legal analysis from now it being a lawful citizen's arrest to it being felony false imprisonment. So now felony false imprisonment is all the way through. You tried to hit him 4 times. You tried to do this because you didn't have a legitimate claim to citizen's arrest. This is all felony false imprisonment. So in that span, while you're trying to commit this felony false imprisonment, he died, right? You don't get the right to self-defense because you don't get the right to try to felony false imprison somebody with a gun, right? That just doesn't happen. So that's why that claim would be suspect now if the self-defense, the citizen's arrest is not valid. So you don't think about this. If I'm doing a felony imprisonment to a woman who I met in the street and I have a gun and she resists and I shoot her, and I can't say, well, she grabbed for my gun, so that's why that's why I'm justified. No, it doesn't work that way. So that's essentially the 2 aspects we're fighting with here. If a citizen's arrest were legal at the time, isn't that enough to allow this angle? Yes. And I hope that's exactly what I explained before reading the second part of the question. So that's why this citizen's arrest piece is the hinge that keeps both sides kind of normal. Nate the lawyer, the 2 bandanas thing was interesting. Yeah. But again, I don't see where they're going with this because it's kind of like these witnesses, like, we all know the reason why he died. He got two shotgun shells pumped into him. So I think it was good to get the fact in that he may have caused his own damage. But I think that was a nice tactic. But again, we are where we are. Nate the lawyer, is it possible to have this not be a citizen's arrest by any reasonable person? Yes, it's very possible. Very reasonable people would think this because of the police action. I think that gives you something. I think the police action gives you something that gives you reasonable. And I want people to take the politics and the race out of it and think about it. If we're searching for somebody who is frequently coming to a house all the time, and the police are certain, and we're searching whether we think he's armed, I think that it's reasonable to also think he's armed at a later date. And so that is reasonable. It's reasonable. And if that's reasonable, if we can all sit here and think that's reasonable, then we have another, then the analysis is different. So people thinking that they didn't assume that he had the gun, or they had no reason to assume that he had a gun. No, they I think they had a pretty valid reason, and one that was reasonable at the time. Was it correct? No, I don't think it was a correct assumption. But just like just like in a lot of these cases, your assumption doesn't have to be correct, but it has to be reasonable based on the facts and circumstances that you have in front of you. And here, the facts and circumstances that we have in front of us, I think would leave a reasonable person to believe, or at least be justified in believing, that he could be armed, right? So I think that's where the hammer's hitting the nail here. Nate the lawyer, did the Michaels physically grab Arbery or try to tackle him? I don't think they were trying to physically grab him. Nope. Well, earlier we heard that they hit him with the car. They were trying to drive him off the road. They ran him into a ditch. So it seemed like they were physically trying to stop him. But they also, it got to the point where they pulled out guns and pointed it at him and tried to get him to stop. Now, at that moment, if they were conducting a citizen's arrest, they're justified. If they weren't, because let's say they were justified in a citizen's arrest and they point a gun at him. Their argument, correct or not, is that we thought he was armed and here's the reason why. And they're going to play that body cam footage. That's what's going on. Oh, thank you, Stacy Lawrence. I appreciate it. Trying to break this thing down. I appreciate the super chat. They called him the N-word, which makes this more racially motivated. I agree. I think that's something. That's something that you definitely gotta bring up. It's obviously going to color what happened, but I think the defense has done a very good job in showing a non-racial reason why this is happening. Right? They've done a very good job. Look at them. All these people. The police were searching for him, right? So that here's all this footage of him doing all this. So I think if you really kind of pin it down, it's hard to get over the calling him the N-word after he shot and chasing him, right? But I think their argument that, hey, there's other reasons other than just the N-word, other than just he was black while we were chasing while we did all this. And I think if you really look at it, you can see that. I'm just going all right. Just, same old, same old. We're going over the Arbery case. So I know over at the other trial, it's stalled, but I'm expecting the jury to come back today. Late the lawyer, did they show the Molotov cocktail thrown? Molotov cocktail. I'm not sure. I'm not sure when the one was thrown. Sorry. Uncivil law was here. If you guys have any questions, I'll ask questions because we're at lunchtime right now and nothing is going on. I might be ending the stream and then doing a follow-up later just on what's going on in the afternoon, but I'm scooping with your pooping, Nate. Illinois v. Wardlow. All right, I'll check that out. So I gotta remember to write that down. Well, first let me know what the citation is for. Nate the lawyer, does the court not recognize an unarmed person? Does the court not recognize an unarmed person as a lethal weapon? I'm trying to understand the context in which you're asking this. Nate the lawyer, does the court not recognize an unarmed person as a lethal weapon? An unarmed. Well, the thing is that I don't know if you guys ever saw a suicide by cop, where people who are unarmed will go up to officers. They'll like rob a bank and put their hand in the pocket like I have a gun. Then the police get there. And they'll be like, I have a gun in my pocket, right? Totally unarmed. And the police will draw their weapons and be like, all right, don't, put your hands up, drop the weapon, put your hands up, and we'll come. And then they'll go in their pocket and do like that. They were totally unarmed. So sometimes it's not about whether they did have the weapon but it is whether there was a reasonable threat, right? Because you don't have to see the weapon. You have to just believe that there's a threat. And that's what this is going into. Whether there was an actual threat, whether it was reasonable to believe that. That's what you're looking for. Anything else going on here? So I hope I'm answering all your guys' questions. I'm trying to go through them meticulously. Nate the lawyer, has your opinion of guilt changed based on this new evidence? No. I still think the problem, the biggest issue that I have here with this case, I still think they still have this guilt, even though my at first I was like 80-20. But now I'm kind of 60-40. And the reason why is because the evidence has shifted a little bit, actually a lot. And the one part I think they have to resolve for them to be found not guilty is they chased this. They didn't know the person they were chasing was the person on these videos, was the person 2 weeks ago. How to resolve that, right? How to resolve that fact of reality. Now, if the jury is going to just infer that that was reasonable to assume that the person that was running down the street when they chased them was the same person 10 days ago, okay. But if the jury can't resolve that inference, was that a reasonable inference to make? And I can see a reasonable jury saying that's not a reasonable inference to make, because the prosecution is going to say that inference was made just based on race. Black man running down the street, right? And the defense is going to say, no, man who, let's remove black, man who fits the description of the burglary suspect, of an armed burglar, of who we believed was an armed burglary suspect running down the street. So that question, I think, now is going to be critical to this analysis. And obviously whether it's a burglary or not, because if they don't find that he was a burglary suspect, they lose. The Michaels lose. Can't hear? Well, all right. I'm sorry, but my volume is up, so I don't know. Yeah, this is, if you want me to ask any questions, just tag me. I'm trying to answer whatever I see in the chat. If a black man calls him the N-word, is that racist? Probably not. But we live in America, and white people chasing a black man, screaming the N-word, killing him, and then still killing the N-word afterwards. I think it leads. It's again talking about what a reasonable person would think, not if it actually is true, but would it lead a reasonable person to believe that he's a racist? I think it would. I think you could infer, but that doesn't mean these people could be the least racist people in the world who just happen to use the N-words, right? Using the N-word doesn't mean they're racist, but if you're talking about what a jury can infer, I think they could. Especially, the freewheeling, the guy's dead, for instance. There's no need to use the N-word there. He'd like he can hear you. Nate the lawyer, if you try to hit or run the police off the road with your car, it is considered lethal. Yes. Does that not start the same time here when they hit him with the car? Yeah. I agree. I think this was too much force to be used. But their response to this scenario is going to be, we thought he was armed. We thought he had a gun. And what are they going to point to? They're going to point to that body cam footage that we just saw, right? Police are looking for him with a gun. Everybody's looking for a guy with a gun. They pulled out their gun. So I agree exactly what you're saying. Yes, but that's going to be their response. Take it for what it will. If you're on the jury, would that sway you? Would that not sway you? But that's their response. Look at the body cam footage. Intrusive Q&A presumes you don't already believe death is imminent by the chase. I'm fighting for my life. Yeah, Arbery was fighting. Well, he believes he's fighting for his life. So, I mean a salad. Trying to save some calories here. Yeah, super chat just came in. Let me pick this up. Oof, boy, I'm far behind. Okay, request suggestion to go through the Trayvon Martin case. Yes, I'll go through that one again. But it's interesting because that happened before I was an attorney, before I kind of knew all this stuff, and it's so interesting to see how my view on that case has changed pretty dramatically. Because I thought that was a straight up assassination by Judge George Zimmerman, but after I became an attorney, after I started understanding these principles of law and looked into it, now I think the jury came out with the right decision. But it's for purely legal reasons, right? And when you do the legal analysis, I think I understand why the jury came to the verdict. And to be honest with you, I probably would have come if I understand the law now that I do, I would come to that verdict. Even though I really don't like it. I don't like the fact that it does, but yeah, I think it was the right verdict. And it's a shame because of because of the facts and circumstances of that incident. But I'll go through it and tell people exactly why I believe that to be true. Using the N-word in the South versus the North, like NYC, is different. Oh yeah, I agree. But again, we're talking about what a reasonable person, right? Who's that jury is going to say, well, what do a reasonable person calling these people the N-words, right? In this situation. And if you do, what does that say about that person? Does it say they're racist? Does it lead you to believe they're racist? Could you infer they're racist? I think we just got to be honest with the facts here. If you don't think the jury is going to infer that somebody's chasing somebody down, a white people chasing a black guy down in pickup truck screaming the N-word, is not going to infer that they are racist or they are not. That they are not. How do I want to say this? If the situation is two white men in the South in a pickup truck chasing down an unarmed black man, using the N-word as they do so, kill the black man, and then over the dead body still call him the N-word, and you don't believe that the jury can infer, right, based on those facts in front of them, that these people are racist, I think we're kidding ourselves. I think you can. I think you can. I think a reasonable jury can infer that. If it's right, if it's wrong, who knows, right? But I think a reasonable jury can infer that. And I think reasonable people can infer that, even if it's the wrong inference. And that's the reason why you got to be careful when you say those type of things or when you do those type of things, because, it's not going to be you you got to get up there and say, well, I didn't mean it. I'm not a racist. Well, that's not what most people are not going to believe that. Most people are going to believe that you are. And that's the reason why you said it. Nate the lawyer, just in terms of what is physically observable, using the N-word is proof positive they are not non-racist. Agreed. Good old Southern boys chasing a black man doing this. Come on, bro. I'm not again, what I'm saying is that the way I explained it is the way that I believe the jury is going to be looking at it, right? Those situations. So I'm saying I can see the jury, of course, inferring that he's racist. There are some people who are in here in this chat who saying that they don't have that inference, but that's what juries are for, right? Some people are going to say yes, some people are going to say no, but I don't believe it's not. I believe it's less. I believe it's less reasonable to think they weren't than they were, but I believe both are reasonable, right? Both assumptions. Just because they said the N-word doesn't mean they are racist, right? But because they did say the N-word in these circumstances can really lead somebody to believe they're racist. So I'm agreeing with you. If you're asking me my opinion, I believe yes. I believe they are what they are, right? They are racist because who does that? But I don't think that automatically means that they are guilty, right? Just because they use the N-word, just because and for the sake of argument, let's say they are racist. Let's say they're blatant racists, right? And I'll just agree they're blatant racists. That still doesn't really change the legal analysis of whether they were justified in the shooting and whether they're justified in doing what they did. I don't believe they were, but the legal analysis now is a little different, right? So that's what I'm trying to convey. Yes, you can believe that, but how does that really reflect on the legal analysis? And that's what I'm trying to get people to understand. The legal analysis is what matters, even though I think this colors it, but that's what really matters. Even granting the whole racism thing, that still doesn't mean that they weren't justified, right? That they could be justified and still be racist. The two are not mutually exclusive. They're racist, they're just not justified. That those two things are not mutually exclusive. Are you aware that Rachel Gentile was not Trayvon's girlfriend? No. His girlfriend refused to testify. Binger is child's play next to Crump. Yeah, Trayvon Martin case. I'll do something pretty deep with the Trayvon Martin case, but I don't. That's a tough case. That's a tough case. Thanks for replying, Nate. Let's hope for the right, not guilty for Kyle and guilty for these guys. Yeah, I think Kyle is not guilty, just based legally based. Like that's just based pure law. I don't think, even if he's convicted, if Kyle's convicted, I think that's just a miscarriage of justice, right? That's just you got some rando, crazed maniac chasing you and running you down. Like how could you not give him self-defense on that? That's kind of ridiculous. Thanks for super chat, but yeah, that's crazy. But this I thought I'm going to say it. I thought this was a slam dunk. I thought this case was a slam dunk. And when I was asked to cover it, I was like, I'll cover it because it's a slam dunk. We'll get to see some people. But now, with this evidence coming out, if it doesn't give you pause, because we all kind of look at things with our own background and our own information. But I like to try to, and the reason why I've had this little streak that I've been going on is because I like to try to look at things. What if this jury is made up of 11 white jurors and 1 black juror? Now, without understanding their politics or race, their experiences as being white is going to be different than my experience of being black. Their experiences in the South, if people are saying here that calling black people the N-word in the South is just like saying hello, that's a different connotation in that area, right? So they're going to be less likely to say, well, just because he used the N-word, he's a racist, right? Because we all use that word. Versus in the North, where if you do use the N-word and you're white, it's a whole different scenario, right? So, but I'm not saying that's the case, but I'm just saying, those perspectives and where you grew up and who you are is going to be different the way you see these things. But I think that's just on the prosecutors, the defense, to say even if they were blatant racist, right? To trying to take that off the table, that doesn't mean that doesn't mean they weren't conducting citizen's arrest. That doesn't mean they didn't believe he was unarmed, and that doesn't mean that they were defending themselves. That's what that and unfortunately, that's the way the law works. If you could show that. Maybe one day a text message, they said, we're going to get the next black person that comes across the street, that comes down the street. We don't want no black people in the neighborhood. Now we're talking about a whole different scenario. But right now, I haven't seen any evidence to that fact, right? I just haven't seen any evidence to that fact. It may be out there. Thank you. It's still legal to be racist. It's not prime, but it's not legal to kill people based on their race, but it is still. But yeah, do I think, and I think people don't want to be mutually exclusive. They couldn't be racist, but they can also be justified. And I think that's the part that people are missing. They're saying race is guilty. That doesn't mean that. Race is more likely guilty? Yes. But racist equals guilt? No. racism could equal, and especially with the evidence that we now have in front of us about the police, about the search, about police asking them to search with the guns. We are talking about a different world we're in today than we were in 2 weeks ago. So Kyle broke the law, getting someone to buy him a gun. No, right? Because the gun was legal. So he could have a gun, right? He could have a gun. And the gun that he had was legal. That was the issue yesterday. Broke the law by taking the gun to a protest, not hunting. No. This is the problem. If he bought the gun, yes, and it was a straw purchase, and I think the kid's doing a straw purchase. But first, we got innocent until proven guilty. So the first part, yes, the way the law works, and this is what I think you may be missing in Wisconsin, and this is what we just learned yesterday. The way the law works there is that if you are 16 and under, you cannot have, own, buy, whatever with a gun, right? But there's an exception for 17 and 18-year-olds, not just for hunting, right? Because the law was written pretty badly. So if you're 17, if you're above 16, and that's 17-year-old, you can have a gun. You can have, but you can only have specific types of guns, these long guns. And if you do have one of these long guns, it's legitimate. You're good, right? And that gun that you have is good. You don't need it just for hunting. But if you're 16 and under, you can't even get a hunting license, right? But you can have one if you did have a hunting license. So the hunting license, if I'm under 16, I need a hunting license to have a gun. But for Kyle, he was in this weird little space where he could legitimately have a gun. And that's why when they asked him, was it a short-off shotgun? Was it the type of gun that you can't have? They said no. So no, he was there legally, right? Because the curfew order was bad. So all this whole thing about him being there illegally, the gun being illegal, all that's been off the table. So he had a legal weapon. He was in a place where he could legally be, right? And he was there. So, if you're saying he broke the law with the gun, if you're still saying that, that's just not accurate, right? The gun charge was dismissed because he was legally allowed to have the gun. The curfew charge was dismissed because the curfew charge was invalid. So he was legal. So that gives you, he's legally allowed to be there and he's legally allowed to possess the gun in that spot. If you want to talk about the purchase of the gun, that may be something, but he wasn't charged with that. So he's still innocent of that. So that's why I'm saying. So I agree with if this was a month ago, I would be like, okay, I understand. But today, no. But he's not guilty. Well, we've resolved the first one, right? He was legally allowed to be there. The gun was legal. Now add that with somebody chasing you down and trying to lunge at you to grab your gun, in that situation. That's self-defense. So I hope I explained that, but that's, I know that's hard to resolve, but that's just what it is. That's what it is. And I know people have been hammering about the whole gun issue now, but the gun issue is a non-issue. The gun was legal and he was there legally. What more do you want? Sorry for multitasking. Has the prosecution made the false imprisonment argument yet? Yes. My belief is you don't kill someone over property. Agreed. In my opinion, these guys look guilty so far. I agree. I still think they are guilty, but they got an argument. They have a good argument, and I can't stress this enough. I don't want people to leave here and be like, "Oh my God, they should be killed." Nate said they should win. They got an argument, and when you got an argument, we have to admit even if you don't agree with their argument, they have a legally viable argument. They have a legally viable argument of why they thought he was armed. They got a legally viable argument of why they thought it was a burglary. Hell, the cops were going thought he was armed, right? So you can't. I think if you're going around not. That's the reality of the situation is one thing, but how does that go into the next piece of it? I don't know. $5 super chat. Thanks again for the super chat. But yeah, he does look guilty. I would be voting guilty right now. But if another juror says not guilty, I can understand where they're going with that. How is this case? This case will decide whether the defense's lack of objections is greater than the prosecution's witnesses. Nate, could you argue both sides? I can argue both sides. For defense's lack of objections is greater than the prosecution's witnesses. I'm not sure I understand this question. How is it this case will be decided, I'm assuming, on whether defense's lack of I don't maybe I'm not understanding the question, but I could argue both sides of this case, but I'm not understanding the question. If you can just tag me, I'll try to see if you're asked, but I'm not understanding the question. The defense in this case and the Arbery case is objecting like madness, right? They are not letting anything go, and so and I do want to say that let's also give credit here to these lawyers. These lawyers are putting on a more professional, well rehearsed, a totally better case than we did see in the Rittenhouse case. This is a more professional judge. I'll just say it. This judge is more professional. The lawyers on both sides are more professional. This is a professional trial, and they're doing a tremendous job of bringing, I think, a little bit more credibility back to the legal profession, because what was happening up there in Wisconsin was kind of a sludge. So yeah, it just that was kind of in self-defense. When Mr. McMichaels and Arbery were wrestling for the gun, which led to Arbery's death, is it fair to say that Anthony Huber was acting in self-defense when Kyle pointed the gun at him? Yes. We had this argument yesterday too on Nick Ricada's stream, and we had on Legal Bite stream. Self-defense isn't exclusive to just one person. So two people, if you have the situation where two people are legally justified to be in a situation, and they can both be legally justified to employ self-defense, even if they're wrong with their assumptions and beliefs about what's happening. So in the Huber case, if Huber was to kill Rittenhouse, all the lawyers that we've talked to said that Huber would have a viable self-defense claim because of the circumstances of the situation. But that doesn't mean Kyle doesn't have a viable self-defense claim to Huber, because Huber's beliefs that Kyle was an active shooter seem to be inaccurate. So if Huber's beliefs that Kyle was an active shooter was inaccurate, then Kyle can still defend himself against Huber's inaccurate thoughts, right? Inaccurate assumptions. But then Huber's assumptions were based on, again, that's what I keep saying, was based on reasonable assumptions. His assumptions were reasonable. Active shooter, that guy just shot somebody. And matter of fact, he just shot at somebody, jump kick man. He just shot 2 shots at jump kick man. So at that point, I think Huber's beliefs were reasonable. And I think you could make an argument that if he killed Kyle, he would have had a viable self-defense claim. And I would be saying he's not guilty based on self-defense too. That's Huber. 10 U.S.C. Section 256, Article 1, Section 8, Clause 16 of the Constitution. 17-year-olds can carry. It all depends on state law. Sorry. I have to look at that. I'm not sure if the article the Constitution says 17-year-olds can carry, but I'll have to look at it. I'm not sure. USC section, blah, 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 blah. And don't forget, we're talking about state law too. We're not talking about federal law. So if this 10 USC section 246, that's not talking about state law, right? That could apply to feds, but state law is different. The state law is a different animal. State law can say you can't carry until you're an adult, right? Even if federal law allows it. So we're talking about state law versus federal law. It's a nice theory, but it wouldn't be accurate based on state law. And that's what they're being charged under state law. But the gun charge is out anyway. He was legitimately carrying a gun. The gun was legal. So it's an argument that doesn't make any sense at this point in time. The gun was legal. The DA and the judge, everybody's admitted the gun was okay. So it is really strong evidence that Travis told the officer, Michaels, that he was armed for reaching for his waistband on an earlier date. Yes. See your stream, the tide has changed. Yeah. Oh, yeah. That's definitely very strong evidence. That's definitely very strong evidence. And the fact that Travis, when his arm, when he fell forward, a lot of people don't realize this from before, but when Arbery was shot and fell forward, his arm was under him. So Travis McMichaels pulled his arm out to see if he had a weapon. And and when the cops asked him, why'd you do that? He said, well, I wasn't sure if he was unarmed because of what happened a couple of nights before. So that also goes into his state of mind of whether he thought he was armed. But now you got to also think, was it reasonable for him to think that he was armed? Right? That's where we're going with that. Let me get the rest of these super chats out. It is illegal to be racist. It is not illegal to be racist, facts. But it sure will not help you. Most jury members. That's true. That's true. It's not helping you in this case. If you're a racist up there in this case, it's going to make it a lot less likely that they're going to think this was justified. They're going to believe that your assumptions were reasonable because your assumptions are going to be colored with that race-based thing. So yeah, so that's not going to be good. Love and respect and gratitude to Nate. Oh, thanks. I appreciate it. So yeah, we had a lot of questions come in, and we still got more to go. So it's there's a lot. You know when the verdict is coming on the Rittenhouse trial. Right now they're deliberating. They're at about 12:45 now, so I'm assuming they're going to be eating lunch. Now it's interesting. A lot of times, I remember we used to have this. There's this old trial attorney that I used to know, and this guy did like maybe 300 trials, and he used to always say, Nate, he used to hate when the jury used to get the cases in the morning, because he said, I know I won the case. He said, I know it's an easy win case. But he said, we always had to wait till the afternoon. And he said, why? Why did you always have to wait till the afternoon? And he said, because the damn jury wanted to eat lunch. So he said, they'll wait till after lunch and they say, okay, we figured it all out. Yeah, they can figure it out like 11 o'clock, but they'll be like, yo, hammer it out. Okay, we figured it out. But he said, but they'll be hungry. They'll want to eat lunch. And they're like, all right, we'll do it after lunch. So he said, we always got to wait till after lunch. So, it's always high thing. I'm not sure they're doing that. Or they'll say before the end of the first day, right? It's either after lunch, or if you still have some holdouts, you'll wait till like the end of the first day. But, or the case that's obvious. But I'm assuming, I'm hoping today. I would think everything is so clear. It seems like today, especially with that closing from the defense, I think today was going to be the day. But we'll see. It may go to the evening and it may go to tomorrow, but we'll see. I wouldn't be shocked if it came back today. If they took 2 days because of the political nature and the politically charged nature of this case, if it takes a couple of days, but right now, I'm assuming we're probably looking at today or probably the day and tomorrow. If it takes longer than that, then my assumption of the jury probably were wrong. But we'll see. I'm still thinking not guilty. I'm not changing that. I still think it's not guilty. Even if it takes a week, I still think it's going to come not guilty. Kyle and Gage be suing the city together for what unfolded. Yeah, I don't know how they sue the city, but they are. Not entirely their own fault, how they perceived each other in the critical moments. Yeah, of course. Yeah. I think Gage had a very reasonable assumption that Kyle was an active shooter. He had heard Kyle shot someone else. He just saw Kyle shoot at one other guy. He just saw Kyle kill the skateboard guy. So yeah, I don't think he's totally unreasonable. But Gage had an illegal gun. Gage lied about having a illegal gun, right? So there's a lot going on with Gage that I think people kind of miss. Gage wasn't a choir boy by any means. IBR says no proof of racism. Well, saying the N-word multiple times, when you're chasing a guy and then, telling the cops when they get there, calling him the N-word, that's proof of racism. It's not proof that you are a racist, but I think it would tend to lead people to believe that you are a racist. Again, you got to be reasonable here. You got to be reasonable. If you think white people calling a black guy who they're chasing down in pickup trucks in the South, running him in the ditches, and then shoot and kill him and see him lying dead on the floor and still call him the N-word, if you don't think that's proof of racism, or at least gives you a reasonable inference to believe that they're racist, I'm sorry, friend. I think you're being unreasonable. I do think that other people can come to that conclusion. I think I can even come to that conclusion. But to say that there's no proof of racism in this case, then maybe you need to just go watch a little bit more of the trial. To open carry provision says no one under 18. Listen, I feel for you, right? I feel for you. What you're saying is the court, the DA, and everybody got it wrong. Fine. Right? That's what you're saying. The court got it wrong. The district attorney got it wrong, right? The defense got it wrong. Everybody in Wisconsin, right? I can't even say they're wrong because I don't practice in Wisconsin. So all the people who live with this law, die with this law, prosecute people with this law, they're the ones who got it wrong, right? That's what they were. They've been arguing this thing for like weeks. And at the end of the day, The prosecutor was like, all right, yeah, well, it's wrong. I don't know what to tell you. If think about this. If he could be charged with that crime, do you not think the prosecutors would have charged him with it? And they did. And it was thrown out because they were wrong. That's just what it is. I get it. It's a hard pill to swallow. It's a hard, because I thought the gun charge was good. I thought they got him on a gun charge. Under 18 with the gun, they got him, right? What more do you need to know? But that's the evidence, right? And that's their interpretation. If I was a Wisconsin lawyer, maybe I'd have something different to say. But I got to trust the judge, the prosecutor, and the defense attorney when they say, okay, this doesn't apply. The gun was legal. Who am I to judge, right? He's literally on trial for it, and they remove it because they believe it was legal. I don't know. Like, what more evidence do I need to present other than that? Because I think sometimes, just like the other guy it's like these comments came in. One guy says there's no evidence of racism. It's like all that evidence of racism is like there's no proof, right? Then the next one is the gun, and it's like, yeah, no, it's all of them said it. I'm not even saying that. That's what they said. I believe them. I believe the court. I believe the rest of them. So I don't know. I understand this is tough pills to swallow, right? Tough pills to swallow. Like you should have saw it when I was doing Chauvin. I thought Chauvin was guilty all throughout the. I did the analysis. I told everybody. I said Chauvin's going to be convicted. It's going to be an easy conviction. Don't worry about it. You had all these other attorneys all around the place. Oh, Chauvin is innocent. Chauvin is innocent. Oh, this. I said, listen, these people don't know what they're talking about. It's obvious Chauvin is guilty. He's going to be convicted. Here's the law. Here are the facts. You just put them together, and and it's not about race, right? I was 100% right? And all these other conservative lawyers, I got to say it, they were wrong. They were absolutely wrong. I think people just got to, the reality sometimes is different than what people, we've all heard these things from the Young Turks and from all these other places, and we want to believe that these false facts are true, right? But we're in court now. They are giving us the facts and saying, here is the facts. Here's what we can prove to be true. Here are the evidence that's relevant to this case. And people want to fight against it. My God, they said, well, the gun charge, he's illegally was carrying a gun now. And people are still saying it was illegal. I can't fight against the court, right? I can't fight. They're saying it's legal. They were prosecuting for it, and they're saying it's legal. How can I get, if you want to believe it was illegal, I don't know what to tell you. I'm sorry. I don't know what to tell you. I understand it. I do understand it. I just don't know what to tell you at this point in time. Am I being unreasonable, chat? And please, if am I being unreasonable? Am I really being unreasonable? Oh, my brother wants to come in on civil law. Sure, you can come in. Shit, he sent that to me half an hour ago. Copy. Let me give my brother on civil law some love while we wait. You guys want to see my friend on civil law? He's going to come in here and argue with me a little bit. Here we go. Control V. And let me call him and let him know that we are here. I sent it to him. I'm old school people. I call people up. Let me see if he's around. He's got to get a better phone. He just sent me a message saying send him the link. So. Yo, I sent you the link. I just saw your message, so you should have texted me. Oh, yeah, let me get a few again then. Maybe it was a bad link. Oh yeah, this is not. No, I saw it. I didn't see the DM. Try it now. Is that working? Let me see, because my stream is. Let me see if my stream is still up. Yeah, my stream is still up. I'm still watching it. I'm watching myself. That's twice I hit you with it. I'm going to refresh the page. All right. Yeah, because I hit you with it twice. So let me know if you can get in. Sorry, guys. I'm on the phone with Uncivil Law, trying to see if I can get him in here. All right. So we got Uncivil Law who's about to join. Let me see if I can click this in and get if I can get it. Oh no, that's not working. The ad link is not working. That's strange. StreamYard. Let me stop sharing. Let me see if this works. That's strange. Sorry, I'm trying to get my friend Uncivil Law in here. Why is this not working? My end. What? No, it's not letting me add anybody to the stream. This is frustrating. Just blind claims. Give me 1 second. I'm trying to see if I can get Uncivil Law. I'm thinking of the grandpa moment. So this is not working. Let me go back because I'm live. All this is good. I'm gonna see if I can just refresh the page.